Oh boy, it looks like you can hear me. Right, we ready to go? All right, folks. Sorry about that. So I said all these really brilliant things, and now you're not going to get to hear them. So I'm going to start all over again. I did want to point out I have been wearing my face mask and then not. And the reason not is because we are properly socially distanced in the room. I also wanted to point out that I made a very bad mistake this morning of losing mine and taking my daughters from the backseat of the car, which I would never in a million years now recommend doing. So here we are. If you don't know me, I'm Anne Marie Story. I am the chair of Rudman & Winchell's employment section. I'm just pausing because now I see another message that says no audio. So hopefully that's going to be fixed. We are here with our 18th annual employment law seminar. We're so happy that you've joined us in this unusual setting, although I think most of you are well used to Zoom meetings by now. We do think we're going to be able to present a really good presentation for you today. We're going to do pretty much the same things that we have done in past years in terms of doing rapid fires for the first part of it. Because, believe it or not, there are things out there still that are not COVID related that we need to think about. So that's the focus of the first part. Then we're going to talk about the earned leave law, which of course I'm sure you don't have any questions about. And then we will spend the rest of the time talking about COVID, hopefully not going over all the things that you have heard a million times. We're going to try and step it up a little bit and talk about some things that haven't been getting quite as much discussion. So almost without further ado, I'm going to turn it over to Karen Zichters. But before I do that, I just want to give a huge thank you to our staff, including Karen and all of our IT folks and everybody else who put this together, because they really worked really hard to do this. So I hope that you enjoy it. And here's Karen.
Thank you. So I have the honor of welcoming everybody to the 18th annual Rudman & Winchell Employment Law Seminar. We've been working hard since March to provide you with regular COVID-related employment updates in order to help employers stay ahead of a rapidly changing work environment during these unprecedented times. Hopefully you've been able to join us at one or more of our webinars hosted by Area Chamber of Commerce's, presented by our very own Anne Marie Story. So we're glad you're able to join us today. Sorry about those early technical challenges, and hopefully they will not be repeated. For those of you who are new to Rudman & Winchell, we are a full-service law firm who's been serving the people and communities of Maine for over 100 years with the resources, personnel, and legal expertise needed to provide sound, effective, and practical legal counsel. Rudman & Winchell has been a strong advocate for businesses, municipalities, and Maine residents, and this annual seminar is one of the many ways that we are committed to helping to strengthen our community businesses. For 18 years, Rudman attorneys have generously shared their knowledge and expertise, along with breakfast and constant coffee refills. Sadly, this year there is no breakfast, but we hope that for those of you who shared your addresses, received not only some of the materials from today, but our little coffee and cookie surprise. So our goal today is to help get you, your employers, and your businesses to the other side of this pandemic, and to share many of the new laws that you will be facing come January, with or hopefully without the added pressure of COVID. So I want to start by taking just a few minutes to go over how this seminar is going to work. By now, I'm fairly confident that many of you have attended a conference in a virtual setting, but just in case, bear with me as we go over just a few details. Since this is a Zoom webinar and not a meeting, you will not have a video option. However, we do want to hear from you. Please use the chat or the questions and answer feature to ask your questions. Notice that those are highlighted in this screen. We are also going to do our best to answer your questions during the section in which they are asked. However, if we don't get to them, we will do our best to then ask them during the final question and answer session of the day. I have Ashley managing the chat and the question and answer features. I have Eric following all of the emails in case you have any technical difficulties or want to ask a question. We are following strict COVID guidelines, as Anne Marie mentioned. We're spaced out, we're wearing masks, and we even have some windows cracked for some extra circulation. So if you have any questions or challenges, please feel free to email us. And why is my clicker not working? At the presentations at rudmanwinchell.com. Both Ashley and Eric are going to be keeping an eye on these communication tools if you need any help. Remember, this is a new format for just about all of us. We've practiced and prepared, but there's quite a bit of technology involved, so please bear with us if we're experiencing any difficulties. So just to let you know, you can come and go as you please. You can use the link that you received in your confirmation email or the email that went out earlier this morning. We all know that everybody is very busy. We're all juggling a lot of things right now, so please do what's best for you. We will be recording this seminar, and I will send out the recording to you by early next week, where you will be able to find the videos on our website. For those of you needing HRCI credit, the code will be sent tomorrow. And for those of you who want SHRM credit, you're going to be able to self-report. So we have a busy conference schedule today. Please note we have 5 different sessions, plus a final question and answer section. We're going to work hard to stay on track. We have sections broken down into about 16 minutes for the first 2 sections for the attorneys to speak. For those of you who want to follow along, all of the materials today can be viewed online. Ashley is putting in the chat bar where you can find those resources directly on our website. So I would like to introduce the attorneys who are going to be presenting today. If you've been to one of our seminars before, you'll be familiar with each of our speakers. But briefly, I would like to introduce them in order of appearance. So first, we have Anne-Marie Story. She has presented at each of the past 17 seminars, so this will be her 18th. Anne-Marie is a frequent speaker to HR professionals and other groups on employment-related topics. She is the chair of the firm's employment law section and focuses her practice on general advising of employers, litigation, administrative actions, workers' compensation, and she regularly conducts employment trainings on a variety of topics, as well as performing HR audits and internal investigations. Our next attorney who will be speaking is Josh Ranlett. This will be Josh's 4th employment law seminar. Josh is not only a member of the Employment and Labor Law Group, but he is also chair of the firm's litigation section. Josh focuses his practice on advising and representing businesses in employment and personnel-related matters. He works to help companies avoid problems, such as providing personnel and HR advice, drafting and revising handbooks, and preparing contracts. He also works with employment litigation related to discrimination and retaliation claims, non-competition agreements, and wage disputes. Our 3rd presenter today will be attorney John Hamer, who focuses his employment practice in the areas of labor law, public sector employment, and workers' compensation appeals. He has appeared before administrative law judges and the court system, all the way up to the Maine Supreme Judicial Court. This will be John's 12th employment conference. Our final presenter will be attorney Brent Singer. Wow, Brent Singer. He advises clients on employee issues, employee terminations, and the enforceability of effect of non-compete agreements. Brent has worked extensively in helping to defend employment discrimination litigation cases for more than 20 years in both state and federal courts, including many cases alleging disability, discrimination, sex discrimination, and sexual harassment. So, not only has Brent been here since the first employment law seminar in 2003, but he also shared with me that way back in 1999, he was part of the very first conversation about whether Rudman Winchell should host an employment seminar. And just to show you how much things have changed in the past 18 years, you will notice the advertisement for the 2nd employment law seminar. So I'd like you to note that the email for where you're supposed to register is going directly to Anne-Marie. I think she would literally kill me if I tried to do that to her today. So fortunately, a lot has changed since 2004, but certainly not all of the informative, educational content you have come to expect over the past 17 years and counting. So now as we are about to begin, I'd like to do a quick technology test and ask everyone a quick poll question. So in light of the yummy coffee that I really hope everyone is enjoying, which of our two panelists are not the coffee drinkers or are the coffee drinkers? So to hear the answer, I am going to turn you over to our first presenter of the day, Attorney Anne Marie Story. And thank you so much.
Hi, everybody. So I'm watching the poll come in, and I got to tell you, the irony of this is that this is a non-question because Karen got it wrong. There is no right answer here. You're still polling, so I probably shouldn't have told you that. But anyway, so there's a little levity for you. And the other thing I need to point out is that my recollection, and I realize it's been 17 years. I don't think Brent was very enthusiastic about this the very first year. But here we are. All right, so with all of that said, I'm going to spend my first 16 minutes talking about leave. And I'm told that the poll is over and the winner was Josh and John, and of course you're wrong. So the actual answer is that John and I are the two Diet Coke fiends, and that Josh and Brent are the coffee drinkers. So inquiring minds want to know, I guess. All right, so my task was to talk about leave for the first 16 minutes. And I found that a little bit challenging because I didn't want to talk about COVID-related leave, because we're going to do that later. And I didn't want to talk about the earned paid leave law, first of all, because I'm tired of talking about it, but also because we're going to do that later. So that left me with what other leave issues might there be at this point. And I did come up with some things that I want to share with you about the FMLA, both state and federal, because they actually turn out to be quite important. Some of them are a result of the COVID situation, but not directly related to it. And some of them are just reminders for you. So the first thing is that there are new forms, federal forms, and you can find those, of course, on the DOL website. I think they redid all of them, but the ones I'm going to talk about are the Notice of Eligibility of Rights and Responsibilities, as well as the certification both of the employee's own serious health condition and that of a family member. These were issued in July. They say that they expire June of 2023. They are not mandatory. I don't know if people realize that you are not required to use these forms. Quite frankly, I think you would be remiss in not using them because the whole point is that it limits the information that you're entitled to have. And as we all know, you do not want to have more medical information than you are permitted to have. So I would strongly recommend that if you don't know these are out or haven't gotten them ready to use, that you do that. I wanted to just go through briefly a couple of the changes in these, and just be mindful, these are the federal forms, but you may still use them for state requests. So if you have somebody who's covered by state FMLA but not federal, you know, Maine doesn't have their own forms, so you can use these. So on the Notice of Eligibility of Rights and Responsibilities, you know, I have to, from a personal standpoint, it looks to me like these forms are a whole lot longer than they used to be. So why they're calling them less complicated, I'm not entirely sure. But what they have done is added some sections, and I think the idea was they are intended to have less narrative, especially from the certifying physicians, so that you end up with less medical information. And also, I think hopefully to make an employee's rights and obligations more clear to them. What I think it's going to do is probably require some additional work on your part. Because, for instance, on the Notice of Eligibility of Rights and Responsibilities, you now have to inform somebody if they do not meet the eligibility requirements, how short they are in terms of time to meet it, and also both in terms of the 12-month length of service and the 1,250-hour requirement, which I don't necessarily think is a bad thing, because you ought to know that anyway, and so there's no reason not to communicate it to the employee. Plus, if there's an issue about it, then it can be dealt with right away, as opposed to denying the leave and then having them come back later and fuss about it. I've seen some commentary about one of the sections in here where it's talking about what the 12-month period is. And because it lists out the 4 ways to calculate that period. So, in other words, calendar year or fixed year or the 12-month measuring back or the rolling. But what it doesn't do is make it clear that those are not the same thing as intermittent leave in terms of calculation. And so I guess there's some concern that employees may not understand how intermittent leave is calculated. So you may just want to be aware of that. And then the final thing I wanted to point out about the notice of rights and responsibilities is that on page 3, there's a substitution of paid leave section now, and it requires you to check off several different boxes about whether or not leave is paid and whether they have to use their own accrued leave. And then there's an other box that talks about whether or not you're going to offset this based on STD or workers' comp. I think that this is interesting because this is going to be impacted by COVID potentially, especially if we have a new FFCRA that starts up in the new year, which we may very well. So that's the notice of rights and responsibilities. And then on the designation forms, both for the serious health condition of the employee and the designation form, it goes through the steps now that an employee needs to take to amend an incomplete or insufficient certification. And it requires you to explain to the employee what's missing or insufficient, and hopefully that will work out well as also because it will be hopefully easier to clarify with the employee what they're missing. In terms of the qualification or the certification of the employee's own serious health condition, one of the things the form now asks for is for the healthcare provider to describe at least one essential function that the employee is not able to do that would qualify them for FMLA, which is a new thing. And interestingly, on the certification for the family member, it now asks what the particular service is the employee is needed to provide, because you'll remember this comes up many times every year, and because technically it's supposed to be of medical necessity. But that term has been interpreted extremely broadly to include anything from medication management to taking somebody to appointments to bringing them home from a nursing home, but even to providing things like psychological care and moral support. And in fact, even going to a nursing home, for instance, to get somebody situated or deal with issues there. So that's been very broad, and that they'll be asking now for specification as to what kind of care is needed. So I think that will be helpful as well. Okay. Since there were new forms, that prompted me to think about one of the categories of FMLA, and I'm not sure I've ever talked about this in a seminar, and it seems like we should as a reminder, and that is that of course, one of the reasons for an FMLA leave is for the birth or adoption of a child or to bond with a newborn. And so what I was thinking is, what kind of form does one use for those situations? And it turns out there is no form. And so I want to make sure that you're not trying to apply one of those forms, because if the baby and the mother are healthy and it's a bonding issue, then there's no medical certification to be had. So you would not be using the medical certification for the employee's serious health condition. And so you can make your own form. You can sort of document this however you choose to document it. I did look up, though, what you're entitled to know. And it turns out that you're entitled to request documentation to confirm the family relationship when somebody asks for bonding leave. So, I mean, good luck with that. I don't know that there would be a situation where you really would want to question that sort of thing. But if you do, you are permitted to ask for that documentation. Although the DOL does point out that if it's the employee is the female who's been pregnant and has been working for you, it wouldn't make a whole lot of sense or be very reasonable to ask her for documentation of the need for bonding or the delivery. So don't do that. It also says that you can ask for documentation of the qualifying family relationship in the event, I suppose, if you have a male who's asking to take FMLA leave for the bonding, then you can ask for that kind of documentation if you feel like you need it. Again, though, be sure you are treating everybody consistently. So if you're going to ask for that documentation from one person, you're asking for it from everybody. And the DOL goes on to say that if you do decide to ask for that information, it can be satisfied by the employee providing either a simple statement asserting their family relationship or documentation like the birth certificate or a court document of the employee's choice, mind you. You're not permitted to ask for one or the other. In terms of the, now keep in mind that the leave, these forms of leave have to be taken within 1 year of the birth or placement for adoption. So that's the bonding leave, not the medical leave associated with a pregnancy if there is any, but the bonding leave and also the placement for adoption. The other thing is, keep in mind that an employee can ask for covered FMLA leave for, well, not so much the bonding, but for the adoption or foster care prior to the actual placement. So I know, I mean, John and I went through this and we had to go to so many meetings I can't even begin to imagine about a variety of things. And that time can be covered under FMLA for the adoption or foster leave as well. And I don't think most people realize that. So, so there's that. Karen, how am I doing on time?
You have 7 minutes.
I have 7 minutes. Okay. So the next thing I want to talk about still under the FMLA is telemedicine, because if you don't already have employees who are treating by telemedicine, you certainly probably will. And I know at least in the workers' comp world, a lot of treatments are being handled that way now because of COVID, of course. And so the question came up about whether or not telemedicine is covered as a form of treatment under the FMLA. And it would be a fairly creative argument to try to say that it's not, which is not to say that that hasn't or won't happen, but the DOL has weighed in on this just in case it comes up. And they have said that, well, just to back up a second, so the requirement is if there's not inpatient treatment, as you probably know for this certifying under the FMLA, there has to be an in-person treatment visit within 7 days of the first date of incapacity, and then continuing treatment after that. And that's one of the ways the employee qualifies for their own personal medical leave. So the question, of course, is, well, if they're being treated by telemedicine, does that still count as an in-person treatment visit? So the DOL actually specifically did address this in that, and we're going to make reference today to a bunch of different DOL documents, I'm sure, and all of those can be found on their website if they're not already in the materials that we have attached to this. A lot of them we did not, print out and attach just because they're extremely lengthy, but they have a document called COVID-19 and the Family Medical Leave Act question and answer. So that seems relevant and important. And it turns out that they did address this, and they clarified that a telemedicine visit will be considered an in-person treatment visit if the visit includes an examination, evaluation, or treatment by a healthcare provider, is performed by video conference, and is permitted and accepted by state licensing authorities. So, note the requirement that I read that says video. So a telephone meeting is probably not, or at least under this definition, does not appear to be enough. And I find that interesting because I have, in the comp world, I have people treating with psychological providers, not for a physical problem, and they are doing those meetings by telephone now. And so arguably those do not fit within this definition and may not be considered in-person treatments. In addition, so, that's something to be aware of. In addition to that issue, the DOL also, well, first of all, it emphasized that this is only true through December 31st, 2020. Isn't that what year we're in? Yeah. 2020. Because all of the FFCRA and all of the COVID rules the DOL has issued pretty much expire as of December 31st, 2020. And so presumably we're going to get updates at some point between now and then about what's continuing and what's not. And so we don't know, but at least as of right now through the end of the year. It also says that during the same time frame, so only up until the end of the year, electronic signatures are acceptable on documents used to establish a serious health condition. So if the employee presents his or her certification of a serious health condition to you with an electronic signature and presumably filled out electronically as well, you have to accept that. It doesn't mean that you have to accept something that's less than completely filled out. You're still entitled to all the information that you're entitled to have, but it can be signed electronically. Okay, so that was the telemedicine rule. Now, the other thing I want to talk about under the FMLA is what's happening with people working remotely, because, of course, as you know, many of the employment laws that we deal with have minimums in a place of employment. So the ADA, for instance, only applies when you have 15 or more employees. But there are guidances about, especially under the FMLA, about where they have to be working. So, for instance, the federal FMLA said that employer is only covered, right, if they have 50 or more employees within a 75-mile radius of the employee's work site. So now one of the issues that's come up is if I've got some percentage of my workforce who is working remotely and is no longer in the office, do those people still count? And does that mean, of course, I had somebody go ahead and ask, so does that mean that if I have them all working remotely, I don't have to provide FMLA coverage anymore? And it turns out the answer is no, not surprisingly, because the DOL has also specifically addressed this. In fact, it was addressed long before COVID. There's been a regulation on the books for a long time about an employee's personal residence. And what it says is an employee's personal residence is not a work site in the case of employees who travel or generally leave work and return from work to their personal residence, or employees who work at home under the concept of flex-a-place or telecommuting. So they anticipated this argument, maybe not for COVID, but at least for other things, and said, in other words, home offices are not considered the work location for FMLA purposes. So you have to count that person in the office from which assignments are made. So if we have an office in Bangor, we've got people working remotely, those people count in terms of whether or not this physical office is covered by the FMLA requirements. I'm at the end of my time. I just want to point out, state does not address this at all. The definition says that you employ 15 or more employees at one location in the state. And because it uses the word employee, I think I would apply exactly the same analysis and count those people regardless of whether they're remote or not. So that's the conclusion of my portion, and I'm turning it over now, I believe, to Josh.
Good morning, everybody. Thank you for being here with us. Last count that I saw is we have about 201 people online right now, which is amazing. So thank you all for being here. And I've got to ask, is anybody else just slightly worried about the fact that it's Friday the 13th in 2020? Because I am, and I'm standing right next to a window that's partially open, and I'm half expecting murder hornets to come flying through there any moment now. So let's hope that doesn't happen. But anyway, my name is Josh Rayland, and I am here to talk to you about updates at the Maine Human Rights Commission and in general litigation about employment-related matters. I've got a PowerPoint to share with you, and I will preface this by saying, I know that you're not supposed to put a ton of text on PowerPoint slides. I tell myself every year that I'm not going to do it. And every year when I sit down to do it, I just can't help myself. It's part of being a lawyer. We are verbose. We like to write. So I apologize for all the text that you're going to see. But I thought it might be helpful for you to have that information. So in terms of the Human Rights Commission itself, I wanted to start by just going over some of the data that they publish annually about the types of cases that they're getting, the amounts of cases, what they're doing with them, because I find that stuff interesting. And so the data that I've got here is actually the 2019 data. This was published after our meeting last year in 2019. So this is new for our purposes. And I don't believe the 2020 is out yet. But in all, in calendar year 2019, they had 715 new complaints, which is pretty consistent with what they had the year prior. It's only about a 1% increase. So it's not much of a change there. In terms of the types of cases that they're getting, the overwhelming majority of them are employment related, about almost 67%. So you got more than 2/3 there that are employment related cases. The next largest category after that is public accommodations, which is 16 point something percent. And then it goes down from there for housing, education, and extension of credit. So by and large, that's the bulk of what they're doing at the Human Rights Commission is employment related cases. When you break down the data to the employment cases, it's interesting to see what the most frequent complaints are that they're receiving. So the most common category is disability. And the data is a little tricky here because in a lot of cases, there will be more than one allegation. So you might have disability with a retaliation or a sex discrimination with a retaliation or whatever the case may be. But this is the data that they were able to put together for us. Almost half of the cases have to do with some form of disability discrimination. That's the largest category. Following pretty closely behind that, though, at almost 39% is Maine Human Rights Act retaliation. And as you all know, that is a claim by somebody who says that they spoke out in opposition to some form of discrimination, or they made a claim under the Human Rights Act, and then they were punished or retaliated against for having exercised those rights. And I think that's an important thing to keep in mind, that this is a very frequent claim that they're seeing there. For when you're dealing with somebody who has made some sort of report or claim or opposed some sort of discriminatory practice, just bear in mind the frequency with which these claims are made. And I'm not saying handle people with kid gloves or don't impose appropriate discipline if somebody has raised those sorts of issues. But you want to be mindful of it. You want to make sure that if this person is in line for some sort of discipline for whatever reason, that you've thought through it beforehand and that you've documented it all very well, so that in the event they later turn around and say, well, I wasn't really disciplined because I was late 27 days in a row. It's because I spoke out that one time. You've got the documentation there to back up and show, no, that had nothing to do with it. It was because of this attendance issue. Following very closely behind Human Rights Act retaliation is whistleblower retaliation, a little over 1/3 of the cases. So again, same issue there. Be cognizant of it. Not that any of you would ever retaliate against anybody, but just make sure that you're thinking through the process and documenting as you go. And then in roughly 1/4 of the cases, they see some form of sex or gender discrimination. And in over 1/3 of those, it's harassment-based. Hostile work environment type claims. In terms of disposition of cases, almost 2/3 of them are resolved before they ever get to the final public hearing, which is before all the commissioners down in Augusta. Some of you may know that the Human Rights Commission in the last few years has really put a lot of focus on their voluntary mediation program. Some of you may have participated in that. I've participated in that. I think it's a wonderful program that they offer, and it looks like that it's being pretty successful. It's got nearly a 2/3 success rate for cases that go there. So that's some interesting data there. And if you've been through that process, you probably know that when you sign up for the mediation, you have to sign a piece of paper basically saying that in exchange for using their process, you will tell the Human Rights Commission the amount of money, if any, that the case settled for. So through that, they were able to discern that in 2019, there were monetary settlements through that process of just under $3 million, 2.929 million, which is quite a lot of money. So that I just found that interesting. In terms of other dispositions, looks like they've got 163 settlements across the board, 132 right to sue letters that have been issued, and 147 administrative dismissals, which I found interesting because I didn't think it was going to be that high. The administrative dismissals are broken down even further, with about 77 dismissed for lack of jurisdiction and 70 dismissed due to the claimant's failure to cooperate in the process or to respond to inquiries. And in only about 37% of cases, investigators completed their investigation and issued a report. So just over a third of cases make it to that point. In cases where investigators do actually write their report, reasonable grounds are only found in less than 20%, 16.8% have reasonable ground findings, to be exact. That's up slightly, about 3% from last year, but it's still surprising how frequently they have no reasonable grounds findings, which is interesting. And in 2019, there were only 93 cases that actually went to a contested public argument before the Human Rights Commission itself. For the cases that did go all the way through a hearing, there was conciliation that was successful in 10 of those. And that resulted in about $44,000 of monetary relief, plus, who knows what for equitable relief. And then in terms of, as you probably all know, the Human Rights Commission itself can file a lawsuit in cases where it deems it appropriate. There were 5 cases referred to the Commission Council for litigation in 2019, only one of which actually resulted in them filing a new complaint. And then they filed an amicus brief in one other case. And as of the end of 2019, the Commission itself had 3 pending cases in which it was a party. So that's my data update on the Human Rights Commission. In terms of the Human Rights Act itself, it's been a pretty quiet year. You might recall that last year we had a number of updates about amendments to the law. This year, due to the legislative cycle we're in, there really haven't been a lot of changes. There was one bill from 2019 that got carried over. It's an act to improve consistency within the MHRA. That made its way to Governor Mills's desk, but then was pulled and amended further and carried over to the next session in 2021. And that doesn't really do a whole lot that impacts our purposes here today. It clarifies that gender identity is included as a protected class for employment discrimination purposes, but that's no real surprise to any of us. I think we've all been operating with that understanding for a long time now. And then it also includes a definition update to familial status to include adult dependents who live with their parents or guardians as a protected class as well. So somebody who's an adult but is disabled for one reason or another, not able to care for themselves. Again, I don't think that's much of a game changer, and I think people had understood that for a while now, but it is going to be reflected if this passes in the act itself. This has been an interesting thing in 2020. As you all may know, OSHA has jurisdiction to handle and resolve whistleblower complaints about COVID-19 issues. So an employee who thinks that they've been discriminated against or retaliated against for having told their employer, I don't think that you're following the proper protocols or this, that, and the other thing, those complaints can go to OSHA. And OSHA has actually been swamped with these things in 2020. As of last week, the latest data that I saw, there were a total of 3,329 OSHA whistleblower complaints filed just about COVID-19. In about 50% of those, they were screened and dismissed right off the bat without any investigation. About 724 were docketed for investigation. 704 were referred to state plans. We don't have one of those in Maine, but certain states have work sharing agreements with OSHA to resolve these things. And as of November 9th, there were 224 of these OSHA complaints still pending. If you find yourself in the unfortunate situation of having an investigation in this, it is not a fast process. The average time frame from intake to resolution, this is as of October 2020, is about 280 days, give or take. And I've actually got a case pending with OSHA right now on this, and I can attest to the fact it is a slow and arduous process. In terms of case law update, again, it's been a fairly quiet year. I have a few cases that I'd like to quickly go over. How am I doing on time, Karen? 5 minutes, perfect. So I've got 3 cases that I'd like to quickly talk about. One is Trahan versus Wayfair, Maine. And the facts here, the employee was a military veteran and she had PTSD. And she worked in a call center in close proximity to other people. She didn't tell her boss or anybody about her PTSD diagnosis. And she had a workplace, the workplace had a rule about treating people professionally and respectfully. Well, one day the employee was talking to one of her coworkers and another coworker interjected into the situation. And the employee thought that that was rude, the way that happened, and told the person who interjected not to be ignorant, and then threw her headset down and stormed off and made a bit of a scene. HR investigated the incident. The employee kind of admitted what happened, but said that her coworkers were in a clique and she didn't like the way that they treated him. And she called them a bunch of expletives. Won't get into that, but she told that to HR, which is not a very wise move to make. She also crossed her arms, stared at the wall, rolled her eyes, goes on through the investigation process. Her conduct is substantiated. Turns out HR is telling her, look, we're probably going to have to take some action here. And then lo and behold, how many of you have had this happen? She discloses at the 11th hour, wait a minute, I've got a disability. I have PTSD. It was triggered by the way I was being treated by my coworkers. You can't discipline me. The employer went ahead, did discipline anyway, which is a termination. The employee filed suit for ADA discrimination. The First Circuit held in favor of the employer, and they had some very favorable language there. It's not anything new, but it's good to keep in mind. The ADA is not a license for insubordination in the workplace, and the employee's emotional outburst plainly demonstrated her breach of conduct rules. So basically, an ADA accommodation request doesn't excuse past conduct, and you can't use it as a get out of jail free card. Another case I want to briefly talk about is Bell versus O'Reilly. This employee worked at a car dealership. He was a manager. He had to work about 50 hours a week, and he had a number of disabilities. He had Tourette's, he had ADHD, he had depression, and when he started, it was 50-hour-a-week job, but due to people leaving, often found himself working 100+ hours a week, which exacerbated his medical condition, and he was in pretty rough shape. So he got a note from his doctor saying that he should not be scheduled to work more than 50 hours a week, or perhaps 45, something along those lines. Presented that to the employer. The employer said, we can't accommodate that. Number one, we think you're doing a fine job by yourself right now. We don't think you need an accommodation, but anyway, we need you to work more than 50 hours a week. So you can't perform the essential functions under that restriction. The employee filed suit, went all the way to the First Circuit. The employee won. And there's a couple of important points here. The most important thing is the First Circuit said that an employee does not have to prove that they need an accommodation to perform their essential functions of their job. They could be entitled to an accommodation if it would be effective to assist them to perform their essential functions. So even if they can technically do it without an accommodation, if there's a reasonable accommodation out there that will make it easier and more effective for them to do it, they might be entitled to that. So you can't just deny it flat up on the grounds that we think that you're doing fine and we don't think you need this. And then the judge said it was up to the jury to decide whether or not one of the essential functions was actually to work 100 hours a week. So that case went back to the jury for another trial. And then the last one, this is brief, I've only got a minute left. This is a case that Brent and myself, and if you recall Frank McGuire from years prior, this was our case, Young versus Maine Coast Memorial Hospital. There's a lot going on in this case, but one of the issues was workplace policy, which the National Labor Relations Board thought was overbroad. And the hospital in this case put in a savings clause, which basically specifically carved out and said, this policy does not prohibit or restrict anything that's protected by Section 7 of the NLRA. The National Labor Relations Board did not think that was effective. They wanted to be more specific about what exactly was protected, when it would apply, when it would not apply. They thought it was too broad. That went all the way to the National Labor Relations Board itself down in DC, who agreed with us that the savings clause was sufficient. which is good news. So to the extent you have workplace policies addressing social media, interactions with the media, workplace civility, might not be a bad idea to put a savings clause like that in there just to be safe. And I'm being told I have used all my time. So I will now pass off to my colleague, John Hamer, who will be talking to you about updates at the NLRB. Thank you.
On murder hornets. All right, well, good morning. And so Anne Reed had told me this morning before we came into work that we'd have one of those fake backgrounds of the ocean. So here I am ready for this. And
I deny that.
all right, so I'm going to be speaking today about the National Labor Relations Board and give you some updates there. I'm sure as everyone knows that daylight savings time was about 2 weeks ago now, and that is our theme for today. And it will become clear as we go through some of the updates. National Labor Relations Board update is appropriate for everybody because even if you don't have a union in your workplace, Section 7 rights still apply to your non-unionized employees. So these standards are important for everybody. All right, so getting to the first standard. The first standard is addressing offensive outbursts, which I believe Josh had just mentioned. Now, on July 21st of this year, the NLRB decided General Motors LLC case. It basically modified the standard for determining whether outbursts are protected activity. Now, previously, there were different standards based on the type of interaction. So if you had an encounter with management, it depended upon the context of the encounter. If you had an exchange between employees and postings on social media, you use the totality of the circumstances test. And for offensive statements that actually occurred on the picket line itself, pretty much anything went, and it didn't matter how extreme it was. If you're on a picket line, you were allowed to do it. So these tests gave the employees a lot of leeway, and it really depended on the situation, and it protected some really, really offensive conduct. So now the board has decided that cases involving offensive and abusive language will be decided in the under the right line test. Basically, it's a two-step question there. General counsel for the board first must prove that the employee's protected activity was a motivating factor in any discipline that follows. And if that's the case, the employer gets to come back and then prove that it would have taken the same action in the absence of the protected activity. So that's a more management-friendly test. Definitely more friendly to management. Okay, pre-contract discipline. So on June 23rd of this year, the NLRB decided 800 River Road. This case overturned a 2016 case called Total Security. So since 2016, the way it was is that after a unit is formed, but before a contract has been agreed upon, so you're still in that negotiation period, management was required to provide the union with notice and opportunity to bargain about potential discipline where there was an existing disciplinary policy before they could impose serious discipline on an employee. So that was the old standard. The new decision in 2020 goes to reinstate a longstanding practice that is not a violation for an employer to exercise its discretion in issuing discipline that's consistent with their pre-existing disciplinary policy. And basically, the employer and the union would have to go and negotiate their contract in due course to decide upon any new disciplinary policies. So this is another case that turns back time a bit. The third category is joint employer rule. I think joint employer rule is important because if you are deemed to be a joint employer, then you're required to bargain with the union that represents the jointly employed employees. So you can be both charged with unfair labor practices, and you don't want to be a joint employer if you can avoid it. So there was a final rule went into effect on April 27 of 2020. The rule basically revised the joint employer standard that existed prior to 2015. Now, in 2015, the board had decided a case called Browning-Ferris. Under Browning-Ferris, a business could be deemed a joint employer if it exhibited indirect control over another employee's conduct or it reserved the ability to exert such control. So that was a very, very broad test, and it was creating lots of joint employer contexts. Under the new rule, to be a joint employer, a business must share or co-determine the employee's essential terms and conditions of employment. So that means it must meaningfully affect matters relating to the employment relationship, and it must possess and exercise substantial and direct immediate control over eight or more core aspects of employment. And those core aspects of employment are wages and benefits, hours of work, hiring, discharge and discipline, and supervision and direction. So this new old standard is much more limited, and it's definitely far more favorable for employers. All right. An employer's right to restrict the use of email. On December 17 of 2019, which was after our last seminar, the NLRB decided Caesars Entertainment. This case basically overruled Purple Communications, Inc. Purple Communications had been decided in 2014, and it basically held that when an employee was given access to an employer's email system for work purposes, the employee had a presumptive right to use that email system during non-work hours for communications that were protected by Section 7 of the Act. Basically, that's going to be any type of joint communications or communications designed to work in concert with others. Now, the Caesars case held that employees do not have a statutory right to use the employer's email to engage in non-work related communications. Employers may control the use of their equipment provided they do not discriminate against the union or other protected communications. So if you're going to allow some employees to use the email system on their off time for personal purposes, then you can't prohibit the employees from using it for union purposes. But as long as you are prohibiting everybody from using it for non-work purposes, then you're good. There was an exception made for where the employer provided email is the only reasonable means for connecting with other employees. So that may apply to some businesses that are very spread out. But for the most part, it's going to restore the register guard test that had been in place until 2014. So a red flag. I know what a red flag means in surfing.
Do you anticipate any major changes with the NLRB as a result of the presidential election? That just came in.
Absolutely, absolutely. The pendulum has gone to one side. There are 4 sitting board members out of 5 places. So eventually people are going to go off the board and the new president is going to be appointing new members. So I anticipate that we'll have some more liberal members of the board return, and the cases will get interesting for a while and probably swing back to the other side. Now, I'm not sure if some of these long established cases are going to be overruled again, which would make our lives very difficult, but I suspect that the trend of conservative decisions is going to come to an end in the near future, not immediately, but as the composition of the board changes, it will change.
Thank you.
Okay, confidentiality in the workplace, in workplace investigations, that is. So on December 17 of 2019, the NLRB decided the Apogee Realty case. And that addressed rules regarding confidentiality during workplace investigations. Now, this case overturned a 2015 decision called Banner Sterling Medical Center, which had held that the burden was on the employer to prove that the integrity of the investigation would be compromised without the confidentiality. Now, Apogee decided, no, that's not the standard we're going to use. We're going to apply the test for evaluating any facially neutral workplace rules. So it established 3 categories of rules that you could possibly have. The category 1 are lawful rules. because either a reasonable interpretation of the rule does not prohibit or interfere with the exercise of NLRA rights, or B, because the potential adverse impact on rights is outweighed by the justifications associated with the rule. So that's category 1 rules, which are permissible. Category 2 rules require individualized scrutiny to determine whether it would interfere with rights, or if the any adverse effect is outweighed by the legitimate justifications. And then category 3 rules are basically rules that are unlawful because they either outright prohibit NLRA protected activity, or the adverse impact is not outweighed by justifications. So the Apogee case held that facially neutral investigative rules that say you have to be confidential in investigations may affect the rights, Section 7 rights, but any adverse impact is comparatively light. So this falls into the category 1B types of permitted rules for open investigations only. So if you have any sort of confidentiality rules regarding investigations, then you're pretty much going to be able to follow them as long as you are applying them to open investigations and equally neutrally. Okay. Union dues checkoff. On December 16 of 2019, again, the NLRB decided Valley Hospital Medical Center, it overruled changes to dues obligations at the end of a collective bargaining agreement that were created in 2015 by Lincoln Lutheran of Racine. This restored the procedure that had been in place since 1962. So absent a contract, there is no independent statutory obligation to check off and remit employees' union dues after the expiration of the collective bargaining agreement. So it basically, once your agreement ends, then your obligations with regard to union dues ends as well. As you can see, all these cases are rolling back time to an earlier age, and maybe we'll have a jump forward in the future. All right, how much time do I have?
5 minutes.
5 minutes, okay. Jurisdiction over religious institutions. This is one of the few areas that actually implicates the jurisdiction of the NLRB. They have no jurisdiction over religious institutions. So the question is, how do you determine if something is a religious institution? Now, in June 10th, the NLRB decided Bethany College, which overruled a 2014 case called Pacific Lutheran University. Under Pacific Lutheran, which has been in place for the last 6 years, management had to prove that the First Amendment concerns that are implicated by showing that it holds itself out as providing religious educational environment, and that it holds out faculty members themselves as performing a specific role in creating or maintaining the university's religious educational environment. So that's a very difficult thing for, not very difficult, but it certainly is an increased burden on management to prove that their individual staff members are actively promoting the religious-based doctrine. Now, the board must decline to exercise jurisdiction over a university that holds itself out to its students, faculty, and the community as providing a religious educational environment. The business or the university is organized as a nonprofit, and it's affiliated with, owned, operated, or controlled by a recognized religious organization. So the individual inquiry about individual faculty members has been removed, and that should make it much easier for religious institutions to take advantage of the lack of jurisdiction over them. Okay, the last section I'll deal with very quickly have to do with the election rules. Election rules can get kind of complicated, but they were amended in December of 2019 to loosen up some of the very strict provisions that had been added over time. These rules were challenged as being unlawfully promulgated. So there's nothing necessarily wrong with the rules, except for the challengers were saying that you didn't follow the correct process for enacting them. So in May of this year, the United States District Court for the District of Columbia issued an order which basically said that 5 of the rules were not properly promulgated and put those 5 rules on hold until they can go through the process again. Given the current composition of the board, maybe that will happen, maybe it won't. But I think it probably will. The 5 regulations that are not in effect deal with giving the parties the right to litigate over voter eligibility prior to having an election. For right now, the old rule remains in effect that disputes about voter eligibility are addressed after the election. The election will not be scheduled for less than 20 business days after the direction of an election by the director. The old rule remains in effect for now, that the election will be scheduled at the earliest date practicable. The requirement that the voter list be provided to the regional office and the union within 5 business days, that was put on hold, and the old rule remains in effect for now, that must be provided within 2 business days. The rule about election observers being limited to current members of the bargaining unit has been put on hold. And right now it goes back to the prior rule of parties may choose their own observers. And the 5th rule is that the regional director will not issue a certificate following an election if there's going to be an appeal. And for now, the old rule remains in effect that the certification can issue even if there is an appeal. So as you can see, all of those rules that were proposed were basically loosening up the very tight timelines for employers to respond or compelling the process to move forward, giving us a little bit more breathing space. But for right now, those are going to be placed on hold. The rest of the rules, I'm glad to say, have gone into effect, and I won't go into exactly what they are. They are in the materials. You're welcome to, and I'm sure you'll be happy to review them when time permits. So at this point, I believe we're transitioning from rapid fire 1 to rapid fire 2. I'm not really sure what the difference is, but step it up. So I'm going to put my mask back on, and the first rapid fire 2 speaker is going to be Brent Singer, who will not be singing.
We hope not.
All right.
That might be kind of funny.
Want me to sing, Henry?
I don't.
Well, thank you for being here. I'll take off my Denver Bronco mask because we are appropriately socially distancing. This is the first time I've given a presentation through a Zoom webinar, and it is odd to think that there is a couple hundred people out there listening to what I say in this room, but because people never listen to what I say. But anyway, I'm going to be talking about non-compete and employment agreements, and I have a short little PowerPoint presentation that I will use. And unlike Josh, I don't have very many words on my PowerPoint slides, but I don't think that's necessarily a virtue. I think I was just lazy, but hopefully I'll be able to explain some of these a little bit so that there'll be some good information that comes out of this. The general idea, I think, about non-competes in my practice, I've dealt with these somewhat regularly now for 25 years, and that there are to a lot of employers, oh, they sound good in theory, well, they just sound good to the employer. But in practice, there's always been some problems with them in terms of whether or not they work effectively as the employer intended. And that has gotten a little bit more pronounced in the last year because of Maine's relatively new statute that went into effect a little over a year ago that places greater restrictions on the ability of employers to use non-compete agreements. Just be mindful that in some, it varies from state to state, and this was Maine's first real plunge into these waters. But in some states, there are much more restrictive things. So if you're an employer that does business in many different states, you'll want to be aware of that. Why is there a bullet that says $51,040? Well, the reason is that under our Maine statute, for this year at least, if your employee, if you have an employee that makes less than $51,040 for the year, you're simply prohibited from having that employee sign a non-compete. It will be unenforceable. And furthermore, you can be fined a fine of not less than $5,000 if you sign someone up there. Now, this law isn't retroactive. So if you have non-competes in place that were in place before September of 2019 that cover employees that make less than this, you're okay. But if you've entered into one in this last year or planning on it in the future here for employees who make less than that threshold, then that's a no-no. And it's indexed for inflation, and so that'll go up presumably some next year. The next bullet there, later of 6 months or 1 year, this is something I think that employers find troubling, because what this means is that if you have somebody sign a non-compete today, it cannot be effective to prevent the employee who might be a former employee by then. It cannot be effective for at least 6 months from the date the contract is signed, or for 1 year of employment, whichever is longer. So if you have a brand new employee and you jump through the right hoops and they sign a non-compete that is compliant with this statute, it still can't even be effective for an entire year. So if 11 months after it's signed, they leave for whatever reason, fired or they quit, it's not enforceable. Whereas if you have a current employee, for example, and they sign a non-compete, they've already worked, say, a whole year, 2 years for you, you still have to wait 6 months before that's effective. The next bullet, 3 business days, what that means is that you have to give the employee at least 3 business days to consider the draft non-compete that you want the employee to sign. And for new hires, if you're going to try to get the employee to sign a non-compete, you have to, prior to the offer of employment, give notice or tell the employee that you're going to ask the employee to sign a non-compete. And that one, if you run afoul of, that is also can be a fine of not less than $5,000. So that's sort of a problem, perhaps, because I can imagine many times when you're trying to attract a new employee, the first words out of your mouth aren't going to be, "Oh, and we want you to sign a non-compete." But if you get too far along the process there and make the offer of employment, and then tell the employee, "Oh, and by the way, you'll need to sign a non-compete," you've now violated the statute. The statute also limits explicitly what it is the non-compete can protect. It can protect only the legitimate business interests of the employer. I am staring up here like there are people out there, but anyway. And the statute identifies 3 legitimate business interests that can be protected by non-competes. One is confidential information, not surprising. 2 is trade secrets, and 3 is goodwill. Yeah, before I went to law school, I had no idea what goodwill meant, certainly in this context. Basically, goodwill is a phrase that's used in case law, but also in when you sell a business, it's one of the things that often is sold. Sometimes it's referred to as going concern value, but in main case law, it means the probability that existing customers of the employer will remain customers. and that's the goodwill of the business. And so if you buy somebody's business, you want the goodwill so that when you buy the business, you get the customers that the former owner had. In any event, you can use a non-compete to protect the employer's confidential information, goodwill, or trade secrets. Now, Maine has something called a Uniform Trade Secrets Act, which already gives employers protection even without anybody signing a non-compete. And under the Trade Secret Act, trade secrets are defined as information that has economic value because it is not generally known or readily ascertainable by proper means by others, and is the subject of efforts that are reasonable to keep it secret. So you can have a non-compete agreement that says prohibits former employees from misappropriating or using trade secrets, and often it's in there. Almost everyone I've ever seen, there's something about that, but it's redundant because there's already a statute that protects that. And also, there's a little known fact, I suppose. Under the common law, that means it's not a statute, it's just case law that comes from now over 100 years in Maine and other places. A former employee is not permitted to use confidential information obtained through that employee's employment against the employer after the employee leaves the employment. And it's often comes under the rubric of unfair competition. And it just means that, for example, an employee of Redmond and Winchell can't, while employed, if that employee is privy to certain truly confidential information, can't then quit, go across the street, and then use that information to compete against Redmond Winchell. Now, of course, they can. It just then Redmond Winchell could then, if it wanted, try to sue that former employee on the basis of the common law, even if there were no non-compete agreement out there. The last bullet here is costing me money versus unfair competition. I often see situations where there is a non-compete and the employer comes to me and they're livid and they want to, put the hammer down on this former employee who's out there competing and taking clients away from them because that former employee is costing me money or costing us money. But when you strip away what the statute says, what the common law says, what all this stuff says, what it really gets down to is the question isn't whether the former employee is costing you money. It's whether or not the former employee is competing unfairly with you. And by unfairly, it's a common sense sort of notion with an objective, unbiased third party who hears all the facts think that there was just something unfair about what the employee was doing, and former employee. And if it's not unfair, then it's just, hey, it's free market. It's what we do in America, free enterprise. And so your chances of succeeding in enforcing it, especially under the new statute, are slim. Part of the problem with the new statute is that it has a definition of a non-compete agreement in it. And so if the particular agreement that you want the employee to sign doesn't fit that definition, it's not even subject to this statute. And I probably unfairly, I criticize legislators too much, I suppose, because they draft these, I've got 5 minutes, they draft these laws and it's so difficult to understand what some of them mean. And In this case especially, I've read the definition of non-compete in the statute many times, and I'm not really sure what it means exactly, but I've given examples here of what it probably means and what it doesn't. The next slide is obstacles to enforcement. Yeah, as an employer, you may be upset, you want to put the hammer down on the former employee, but you know, we live in a relatively small community, and you really do have to think about how that's going to make you look. The $10,000 to $40,000 is a conservative estimate of how much the legal fees would be to go out there and put the hammer down. And even if you win, a lot of times there's a fee shifting provision in the contract, but good luck trying to collect after you, quote, win. And in these, at least in reported cases and in the cases I've been involved with in litigation, the facts are hard to prove. They just are. It's very fact intensive, and that makes litigation more expensive when there's lots of facts, lots of witnesses. So the conclusion is for non-competes, one form most definitely doesn't fit all. They're more difficult to write now than ever before, more difficult to put into place, more difficult to enforce, but they're still worthwhile in some situations. Now, in my remaining 2 minutes or so, I'll talk a little bit about employment agreements. The first thing to keep in mind is that there are as many different types of employment agreements as there are types of employment, and there are a lot of different types of employment. And so when somebody calls me up and say, oh, just give me your form employment agreement, I go like that, because there is no such thing. You know, it depends on the type of employment. Certain professions usually have them. I put them down there. They won't shock you. Physicians, dentists, eye doctors, et cetera, high-ranking academic administrators like chancellors, for example. Certainly publicly traded company executives. Commissioned salespeople almost always do and have some sort of contract, because their compensation can be very complicated sometimes. Former owners of small businesses who sell their business. I got a business, I sell it to Anne Marie, but I want to stay on for a couple years. And so we enter into a contract where basically I don't have to do much as the former owner, and I still get paid, and she promises to pay me.
She's not going to.
Yeah. Now, there's a litany of stuff to consider in employment agreements. They're not shocking. Certainly the term of the agreement, term of the employment. You can still have at will. The contract can specifically still say you're an employee at will, can be terminated with or without cause, so forth. The agreement says, well, what will terminate the employment? Disability? Will it be just for cause? That's, you know, where the employee does something naughty. Then you have to think about how to define for cause. Usually, for whatever reason, it's if the employee does something wrong, they get terminated for cause. If the employer does something wrong, the employee can terminate the contract for, quote, good reason. But other things to deal with are ownership of intellectual property rights. Almost always the employer retains exclusive ownership of any copyright, trademark, patent, et cetera. Though not always, and that can be a bone of contention. You want a non-compete, non-confidentiality or confidentiality agreement. Benefits, things like vacation insurance, deferred compensation can get very complicated very quickly with tax issues. I usually, again, that's something where in theory it sounds like a good idea, but in practice it can lead to all sorts of issues. And of course, compensation, most not shocking, the litigation or disagreements I've seen in the end are about compensation. Somebody thinks they were entitled to more than they got. Bonuses are very, I see formulas, you know, to calculate bonuses. I have no clue what they mean. In other words, my client hands me this, say, well, we've agreed upon this formula, and I read it and I just, holy cow, I can't understand what this means. Does my client and the employee understand it? Even then, it should be rewritten probably. Dispute resolution language, duties and responsibilities of the employee. Mood lighting, is the employee permitted to work elsewhere or not? Expenses, do they get to, how for their out-of-pocket expenses, what do they get reimbursed for? This comes up more than you might think. Where are they going to work? They don't want to work somewhere else. They want to stay there. I've now got the hook, which is, but it was a very, very kind hook. So I will bid adieu. This was, after all, the first rapid fire of phase 2, part 2.
Second rapid fire.
Second rapid fire. So now we'll go to the second of the second rapid fire. And
Just sit
Josh
down.
will speak about wage and hour matters. Thank you. Go Broncos.
Gotta keep everybody on track.
Doing a good job.
Thank you, Brent. Non-compete issues actually happen to be one of my personal favorite things to think about and do. So that was interesting. The way that I'm not here to talk about that, but the way I always think about those are asking 3 questions. Why is it unfair for this employee to compete in this way? And I think if you think about it that way, forget the fact that they signed a contract, unfair for this person in this way, that'll get you kind of in the right foot. But I'm not here to talk about that. I'm here to talk about wage and hour issues. And even in the circles that we run in of labor and employment lawyers, a lot of people's eyes gloss over when you talk about wage and hour. I happen to like this stuff. That probably means there's something not quite right with me, but we'll try to make this enjoyable for you. So a few changes that are coming down the pike. You're probably aware of most of these. Let's talk about minimum wages. On the federal side, the minimum wage is still stagnant at $7.25 an hour, which I do a double take every time I see that because it seems so incredibly low. I don't even know when the last time it was updated, but it's still there. Who knows what will happen, but that's where it is. The main minimum wage, as you all know, it's currently $12 an hour. And this year was the final year of the automatic $1 per year increases. So we're now out of that. And now we increase annually on January 1 of each year, tied to the consumer price index for the Northeast region. So it's tied to inflation. So every year around this time, the Maine Department of Labor will issue updates to say what the minimum wage is going to be for the next year. And they've recently done that. So for 2021, it is going to be $12.15 per hour. So that has impacts in a couple different areas. Number one, of course, is the regular minimum wage, but it also impacts your exempt employees to the extent that you have any. In order to maintain that exempt status for salaried employees, you are going to want to adjust their salary to reflect the 3,000 times of the minimum wage. So what that means is for 2021, the salary is going to have to be $36,450 a year, or about $701 a week, to maintain that exempt status here in Maine. So make sure that you take a look at that and ensure that you're in compliance there for next year. Something you've probably seen in the news is Portland has passed a new ordinance about minimum wage and whatnot. And I'm not sure if any of you have offices or do business down in Portland, but in case you do, I wanted to briefly talk about it. What Portland did was they defined their own thing called the quote minimum wage rate. And it's going to be in addition to, it's going to be more than the state minimum wage, and it's going to increase every single year. And I think it's going to start at $13 an hour. But interestingly, the way that they wrote it is it starts January 1 of 2022 and increases yearly thereafter. And then the big thing that you've probably read about in the news is they have this new thing called emergency proclamation pay, which basically says whenever the governor's declared a state of emergency, like we're in right now, workers in Portland are entitled to this proclamation pay, which is 1.5 times the minimum wage rate. So a lot of people are thinking that that means beginning next month, the minimum wage rate in Portland plus the 1.5 times that for the pandemic pay or the proclamation pay is going to mean workers are going to be entitled to $18 an hour. I don't think that's the case, and there's going to be some litigation coming down the pike on this. The problem with the ordinance that was drafted is they specifically tied the emergency proclamation pay to the quote minimum wage rate. And the quote minimum wage rate starts January 1, 2022. So the way that I read it, and you might have seen this, the way that the city of Portland reads it, is the proclamation pay, at least in some schools of thought, will not take effect until January 1, 2022. There's been rumblings on a number of sides here that this is going to go to a lawsuit by proponents of the legislation who want it to take effect immediately, and others on the business side that don't want it to take effect immediately. I'm flagging that just in case you have offices in Portland. Keep an eye on this. I think this is going to get a lot of attention, and I think it's all but a certainty that it's going to go into some form of a lawsuit. But as of the moment, the city of Portland is not enforcing proclamation pay until 2022. So that's my state and local wage and hour update. It's been fairly, I see that we have a question. It says, that's the state of Maine minimum wage, not the federal, correct? So the $12.15 an hour is the state of Maine minimum wage. So if you have employees here in the state of Maine, that's what you need to be paying them. And then the minimum wage rate, which I'm talking about in the Portland ordinance, is something specific to the city of Portland. That's not statewide. So other than that, it's been fairly quiet in the state of Maine in terms of wages and hour issues. But there have been several opinion letters from the United States Department of Labor that I think are instructive and helpful. And I'll go through some of them with you. So as you might know, the Department of Labor issues these opinion letters to help clarify the regulations every now and then. And one of the ones that they did comes from an employer who wrote it and said that they have this non-discretionary training bonus. And basically it works like this. The employee signs up for a 10-week training program. They finish the 10 weeks. They have to agree to sign up for an additional 8. And when they do that, they get paid $3,000, non-discretionary. You finish the 10 weeks and sign up for 8 more, you get the $3,000. Even if they never end up taking the second 8-week program, they get to keep the $3,000. The question is, does that $3,000 bonus count as part of their quote regular rate for calculating overtime? And this is what the Department of Labor had to say about it. Yes, it is included because it's a non-discretionary bonus. So under the federal regulations, generally all non-discretionary bonuses are included within the regular rate for determining overtime. So then the question becomes, how do you figure out where to apply that $3,000 bonus? And they said that under this circumstance, where the employee had to do 10 weeks worth of training to get it, you apply that $3,000 pro rata over that 10-week period. And to the extent that they work more than 40 hours in any week during that period, you would include that amount, the prorated amount, within their base rate to figure out their overtime pay. So just in case any of you guys have any similar programs, keep that in mind. Another bonus issue that the Department of Labor has addressed is longevity pay. And what happened here is a city had a program where employees who were there for at least 5 years got a $2 a month addition, longevity pay, for every year that they had been employed. And again, it was non-discretionary. If you're there for more than 5 years, you're entitled to this. And they had treated that as part of the regular rate, but they got a little tricky. They wanted to get clever with things, and they said, well, if we, instead of paying it out throughout the course of the year, what if we pay it out in a lump sum at Christmas time? And we call it in the nature of a Christmas bonus, because sometimes Christmas or holiday bonuses can be excluded from the regular rate. They said, will that take us out of this? The Department of Labor said, nice try, but no, that's not going to get this out of the regular rate. They said it's a non-discretionary bonus, so it's not in the nature of a gift. A gift has to be something that you can choose to do or not to do. And so it doesn't matter if you're paying in a lump sum at the end of the year at Christmas time or in each paycheck. If it's a non-discretionary bonus, you include it within the regular rate. So nice try, but it didn't work. Okay.
Josh, can I ask a question? We have a question up
Sure.
here. There's some considerations if our organization is interested in hiring a competitor's provider who has a non-compete. Yeah, good
Yeah.
point.
Maybe we'll address that in
We'll come
the
back.
plenary
I
session.
disagree.
Yeah.
I'll say that.
Okay. So I've got 5 minutes left. So I'm going to skip one of the opinions to one that I think is more interesting. Opinion letter 15. And this is about compensability of time spent in training. So the general rule is time at lectures or meetings or training programs are not working time for overtime or for purposes of being paid if all 4 of the following criteria are met. It's outside their regular working hours, attendance is voluntary, the course or training is not directly related to their job. There's a couple carve-outs there. If it's through a bona fide educational institution, or it's a program offered by the employer that's similar to a bona fide educational program, those are the carve-outs there, but the employee does not perform any productive work during the training. If you satisfy all those, you don't have to pay for training. So what they did in opinion 14 is they went through a number of different scenarios to say, would this be compensable or not? They use a lot of examples about online webinars. So if it's an online webinar that somebody can access anytime and satisfies continuing education credits for some sort of licensing program and is directly related to their job, but the employee will view it after hours, is that compensable? The DOL said that's actually not compensable. You don't have to pay for that. And the reason is because since it has continuing education component to it, it is the same thing as a bona fide educational program. And it's being done outside of work and it's voluntary. So that doesn't have to be paid. They run through a number of different scenarios here for training. I've only got a few minutes left, so I won't go through all of them, but you've got it in the materials. One last opinion letter that I do want to get to, because it, I think, is applicable to a lot of people, has to do with compensability of travel time. This is opinion 2020-16. So in this case, it's a construction company that has a physical location where they keep all of their trucks. And salaried non-exempt foremen have to get the truck at the beginning of every job, drive it to the job, and then bring it back to the work site at the end of the job to keep everything secure. And sometimes the workers, the laborers, will ride with the foreman, and sometimes they'll go directly to the job site. The question is, under what circumstances does the foreman have to get paid for that driving time? And under what circumstances does the laborer have to get paid? So if it's a local job site in the same town or close by where the principal place of business is, and the foreman drives to work, gets the truck, takes the truck to the job site, goes back at the end of the day and goes home, the foreman has to be paid for that time spent driving the truck from the place of business to the job site and back, because that is an assigned required job duty from the employer. So you have to pay for that. For the laborer, if they choose to ride to the job site with the foreman, you don't have to pay for that in this scenario. And the reason is, if the laborer had driven from home directly to the job site, that's normal commute. That's not compensable. And the fact that they chose to go with the foreman instead of doing their own independent commute doesn't change the circumstances. Now, to play with a little bit, what happens if it's a remote job site far away and the foreman and the laborers have to stay over at a hotel? Again, the foreman will drive there to the place of business, pick up the pickup truck, go to the job site. They stay at a hotel for a few days till the end of the job. then the foreman drives it back to the place of business at the end and then goes home. And again, the laborers can choose if they want to go independently or if they want to ride with the foreman. Again, in that situation, the foreman has to be paid for the drive time to the job site and back because it's a requirement. For the laborers, it depends if they drive their own personal vehicle from home to the job site and the driving cuts across their normal working hours, that's compensable, even if they're doing it on a non-work day. So if Sunday afternoon they're heading out there to get a start on the workday on Monday, and they're driving during normal working hours, that's compensable. Same thing for the way back. Same thing for if they choose to ride with the foreman. If the ride cuts across their normal business hours to a remote job site, they need to be paid for that. And then the last one is the same situation where they're at a remote site with a hotel, but the laborers, instead of staying at the hotel, decide to drive home every night. They drive home and back. And the question is, do they have to get paid for that? And the DOL said in that, they do not have to be, for when they first go at the beginning of the job and home, it's the same situation as number 2. If it cuts across their working day, they're paid. But in the interim, if they go home and back every night, they don't have to be paid for that. And the reason is because at the end of their day, when they could go to the hotel, they're completely relieved of duty and they can do whatever they want. They can watch TV, they can play cards, they can go out to eat. If they choose, because of their own personal preference, that they want to go home instead of hang out at the hotel and do whatever they want, that's not compensable working time, so they don't have to be paid in that situation. So to those of you who might be contractors or be involved in the trades and you have employees who travel to different working sites, take a look at some of those DOL opinion letters because they're very informative. I'm out of time, so now next will be Anne Marie Story, and she'll be coming to talk about some miscellaneous updates.
Okay, hi everybody, I'm back. So normally in our yearly seminar, this is the place where we do the legislative update. But there is not a lot to talk about that's not COVID or earned leave law related, which of course we're covering in separate sessions. So once again, I went searching for things that I could talk to you about and create problems for you that you didn't know existed, and I have successfully done that. So I'm going to talk about a couple of things, starting with pronouns, because I have started to see a lot more issues revolving around the use of pronouns toward employees and specific requests that certain pronouns be used, and then some problems that have resulted from that. So what I'm talking about is that I'm sure you know, Maine state law and also the federal law covers gender identity and expression as protected categories. And as part of that, there are employees who prefer to be referred to in a particular way. That may not be the same as their physical appearance or their physical gender, but that's, employees are making requests, and you need to know how to respond appropriately. The bottom line is that, and the EEOC has actually already addressed this, and what they have said is you must allow an employee to express their own gender, and you must be respectful and use whatever gender they designate for themselves. So you aren't to question it, and in fact, this sort of goes along with last year, the issue about bathrooms not being designated as any particular gender. And so the EEOC has actually said that prohibited acts include intentionally and persistently failing to use the name and gender pronoun that correspond to the gender identity with which the employee identifies and which they have communicated to management and employees. And failing to do that, so not even being, I don't know what the right word is, nasty per se about whatever the identity is, but just failing to use what the employee has asked you to use can potentially create a hostile work environment. So, so that seems simple enough, except that I discovered that there are several cases where other employees or managers have raised issues about their own religious beliefs, and how the use of a particular pronoun that they don't associate with that person from a physical perspective violates their right to express their own religious beliefs. And specifically, in one of the cases that I found, what this manager said is that so the person was a female physically a female, but asked to be identified as a male and referred to as he or him or his. And this manager refused to do that and said that it was his religious belief that everybody is whatever gender they were born and it can't change, and he was refusing to refer to this person in that way. And that created a hostile work environment. And so I just want to make sure everybody's aware, if in the event that becomes an issue, that is an obligation. Also, I found a reference about the EEO-1 form, because if you have noticed, it only has boxes for male or female. And what I discovered is that the EEOC recently issued a fact document that said that employers can report the actual, so for instance, if somebody reports as non-binary, you can put that in the comment section as opposed to checking male or female, because the act of requiring a non-binary person to check male or female violates their rights. So, so there it is. Oh, and so here was the dichotomy, the issue with the person who had the religious objection. So now you're in a situation where you've got one employee claiming I have rights to be called whatever I want to be called, and you've got another employee saying I'm not going to violate my religion. And so you have to try and accommodate both. And this isn't uncommon that you've got competing beliefs and competing accommodations. So one way to accommodate is that the EEOC has actually said that using the pronouns they or them is recognized officially as an appropriate alternative. So you can have the manager use terms other than he or she that are non-gender related. So them, they, that, theirs, or whatever. Or use a first name, or however you want to handle that situation. But keep in mind, you can't completely disregard the person who raises the religious issue either. All right, now, yeah.
There's a question, do you by any chance have the case citation for the case relating to preferred gender pronoun?
I don't, sorry.
Would you like me to try to find that and get that out at a later date?
Okay.
Gotcha.
Okay, so to change gears completely, I want to talk about flu shots. A lot of people already have them. Everybody's being encouraged to get them. And for me, they raise issues not only general employment related, but also workers' comp, of course. And I'm going to talk a little bit about workers' comp in the COVID section later on, but let's suffice it to say, for purposes of this discussion, and I'm sure that most of you have heard me say this many times, if you as the employer either require or even strongly recommend, and what that means is a sort of a gray area, and the cases will look at, the board will look at, what did you do in order to encourage the employee to have this shot? So if you're one of those employers who puts up 45 signs in the workplace saying, don't forget to get your flu shot, they're being held available in the kitchen today, or we strongly encourage you to have a flu shot, or we frown on people who don't have flu shots, or it's your civic responsibility to have a flu shot. Any words like that, any strong encouragement like that is most likely to result in a finding that any adverse effects from the flu shot will be work-related and covered by workers' comp. On the flip side, if it's entirely voluntary, and ways that make it appear more voluntary are, for instance, if you open it up to family members as well, if you allow people to have it off duty and in fact don't pay them for the time during which they're having the shot, and you make it very clear in whatever signage you're putting up that this is a voluntary process, then you may be able to avoid comp liability for whatever happens. But this year, things are a little bit different because of COVID, and there has been a lot of encouragement to get flu shots more than usual, and you know, the reasoning is sound, because the idea is if everybody gets a flu shot, then presumably if you develop flu-like symptoms, then we can more easily rule out the fact that you have flu, and then it becomes more likely that you may be COVID positive. And so that's sort of the thinking about it. That doesn't change anything though about workers' comp liability, just so you're clear about that. I did see that DHHS in October had proposed adding seasonal influenza vaccination to the required immunization for healthcare providers, because if you're a healthcare provider, you know that you are required by law to have certain vaccinations no matter what. Most employers who are not healthcare are not subject to that rule. And apparently there is a movement afoot to add the seasonal flu vaccination. The last I saw of that is that the comment period went through the end of October, and then there was a question about whether or not there was going to be an actual hearing about it, and I don't know what the result of that is yet. So that's sort of pending out there. If it is included, then you would be required, and then there would be an issue about whether or not somebody could object to having that vaccination, just like any other vaccination, on the basis of disability or religion. And so I think you probably are clear about the disability issue. There are people who have medical conditions that don't enable them to have certain shots. And so if that were the case, you are entitled to ask for documentation from the doctor about that, but you can't force somebody to have a shot. What you would have to do is accommodate by allowing them not to have it, and then it may mean that they have to change positions or something has to happen, because if they can't work in a certain area without it, then that would have to be an issue of accommodation. The religious-based issue is more interesting in a way, because it has raised issues about whether or not the conditions or the reason why somebody doesn't want to have it is actually a religion or not. And you probably know that religion under state and federal law in terms of accommodation is defined very broadly. So it's any moral and ethical belief sincerely held with the conviction of what a religion is recognized as. And there really aren't any other parameters on it than that, other than it's sincerely held. So, but what it does not include is a sort of a social philosophy or moral compass. And so that line sometimes is hard to draw. And one of those cases is where somebody claimed to be a vegan. And based on their status as a vegan, they said that they were not going to have the shot because doing so would force that person to consume animal byproducts, which were in the vaccination. And she said that violated her religious and philosophical beliefs as a vegan. Sadly, from my perspective, there was no decision in the case because there was a suit filed, but then they settled, and so we don't know what the outcome would have been. I think it would be really interesting to know that, because the line, as I said, is very unclear, and there are things that you think might be covered as religions, and then they're not, and they're said to be social beliefs instead, and so so I don't know, but you need to be aware that that could be a potential issue. The other thing is, I mentioned one thing that's clear though is that objecting to a vaccination because there are people who just simply don't believe in them, don't want to have them, don't want to engage in that kind of treatment. The courts have said that just because one disagrees from a medical or philosophical perspective isn't enough to warrant an exception. Of course, the medical being unless there's some other actual reason that the doctor will certify. One of the things that was interesting about this, though, is that when the EEOC addressed this recently about a mandatory vaccine policy, they actually said, as of the date this document is being issued, there is no vaccine available for COVID-19. And so there's some discussion about whether that was intended to mean when there is a vaccine, and of course that's all over the news now, that there might take a different perspective on whether or not you can require somebody to have that. And that's going to be a whole nother ball of wax. So stay tuned for that. So Karen tells me that I have 5 minutes left. And what I want to do quickly, just because we've been talking about a lot of different leave laws and medical stuff, is just a reminder. And I've done this seminar before on this topic for an entire hour. So I'm just going to do a general reminder to you. The leave laws in Maine, the FMLA, the ADA, the Maine Human Rights Act, and workers' comp all have very different parameters on what information you can get and how you get it. And it's very confusing when you have an employee who fits under more than one of those categories. So for instance, if you've got somebody who's on FMLA and their workers' comp is running concurrently with it, and maybe it's a disability too, you could easily be in a situation where you're thinking, what am I allowed to have, and how am I going to violate the employee's rights by getting too much information under one statute and not enough under another? So I just want to do a very quick reminder that the FMLA, you use the forms, it intentionally limits what you're allowed to have. If the forms are not completed completely, they're not complete and sufficient, you may ask for follow-up for clarification and authentication only after you give the employee the opportunity to cure the deficiencies. And you cannot have a direct supervisor do any of the contact. That's a very, very brief overview of FMLA. ADA is very different. And you might be asking for clarification about whether somebody has a disability, or you may be asking for clarification more frequently about what a reasonable accommodation is and why it's needed. There are a lot of steps that you can go through to get that information, because you're entitled to medical information to support a request for an accommodation. You can, if the documentation is insufficient, you can start with the employee, you can explain why it's deficient, you can ask them to fix it. As we all know, there are many times when that does not work. You may actually consult with the employee's doctor, but you may not do so without express permission signed, by the way, from the employee. And my view is you don't do it unless the employee's in the room with you to have that conversation. So that can never be said that you asked things you weren't entitled to ask. You may ask the employee to sign a release so that you can send a list of questions to the doctor. If you don't want to have verbal communication, you can do it that way. You can require an employee to go to an evaluation by a doctor of your choice, which is really sort of a last resort. I would always try and work it out with the employee and his or her own physician first. But the bottom line is you are entitled to much more information under the ADA and different ways of getting that information. Now, on the flip side, workers' comp, you sign that, or the employee signs the release form that's provided by the board, and you must use that release. And it only authorizes written communication. So you can't just call up a doctor and say, hey, tell me about the employee's restrictions, or, are they credible? Are they doing the right thing? What's the problem? And so on and so forth. So what the problem comes in, of course, when one person fits under many of these different statutes. And the bottom line is that, see, now I got my 1 minute sign. So how fast can I talk? The bottom line is, having somebody qualify under one statute or another does not disqualify you from the information that you would be entitled to get, even if you get more. I don't know if that makes sense. So if somebody's under FMLA and ADA, you're entitled to get what you can get under the ADA, and you can use that information to support claims for outages under, for instance, the FMLA or workers' comp. And I guess what I'm going to do is, the bottom line is, don't make assumptions and call me if you have questions. So now we've reached the point of our 11 a.m. break.
Yes.
And we will be breaking until 11:15, and we will see you back here then. Thank you. Thank you.
All right, welcome back, everybody. I hope that you had a chance to enjoy your lovely Rudman Winchell coffee. Can you have a couple people just give us some signs if you can hear us, because we'd like to know that you are being able to hear us. If there's anyone can post a comment saying yes.
Yep.
I got thumbs up, so that's good. That's great. All right,
Oh my
perfect. Thank you.
gosh.
Okay.
All right, that's
Okay.
enough.
Holy cow. All right. So 13 days until Christmas, 27 days until Hanukkah, 42 days until Christmas, and then 49 days until earned paid leave. It works better when there's a bigger crowd. All right. So we're going to talk about earned paid leave and what needs to be in your policies. I'm going to start talking about some of the basics for earned paid leave, and then we're going to open up to the fine panel and my wife, of course, and Marie, who will correct me whenever I misstate anything. So hopefully we'll have some good information for you. So as we said, the earned paid leave law takes effect January 1st of 2021. So that does require a little bit of preparation to have some policies in place to deal with that. So you'll be ready for it. Just a note that you should be using the regulation of employment poster that was revised in September 2020. If you haven't updated your poster, you can get that online and print it out and post it. So the first question is really, what's the applicability of this new law? So this new law, which isn't really a new law, it's an old law, but it's just taking effect. It applies to an employer that employs more than 10 employees in the usual and regular course of business for more than 120 days in a calendar year. So if you are well over the 10, then you don't have to worry about it, you're covered. If you're right around the 10, then you might want to take a closer look to see if you've had those 10 people employed or 11 people employed for that sufficient period of time to get you through the 120 days in a calendar year. Who are you counting? You're counting all full-time, part-time, per diem employees if they've worked enough time, but basically anyone who's employed by you is going to be potentially covered as long as they've worked enough time to get you the numbers to cross that threshold. If you've got employees who are located outside of the state of Maine, you're going to look to see basically if they're covered by unemployment in Maine. And if they are covered by unemployment in Maine, then you got to count them if they work sufficient time in the state. And that also means that they'll be entitled to the leave as well. If you've got an employee that works in multiple states, then there's a bit of a more in-depth analysis of whether they would receive the benefit and whether they work enough time to be covered. So you might want to consult with counsel at that particular point if that's the nature of your business. But basically, if an employee is covered by an employment in Maine, then they're going to be covered by the law. So the question is whether they've worked more than 120 days in a calendar year to be counted. And if you are covered by the law, then they'll be entitled to the benefit along with other employees. One note, the 10 employees or the 11 employees need not be located in the same single place. As long as they're within the state of Maine, that's fine. So if you've got 2 locations in Maine and you've got 15 employees between the 2, you're going to be covered even if there's not 11 in one particular location. Okay, the earned paid leave entitlement. As I mentioned, employees, whether full-time, part-time, contract, or per diem, they're entitled to earn this earned paid leave. There are a couple exceptions. First is agricultural workers and domestic workers in private homes. They have special rules that will govern them, and they're more in depth than we're going to go into here. So if you have a question about agricultural workers, then you should consult with counsel. Otherwise, employment in a seasonal industry. Now, a seasonal industry is an industry which, because of the seasonal nature, is customary to operate only during a regular recurring period of time, less than 26 weeks per year. So if you have a seasonal industry, then you are exempt. Student interns are exempted, provided they meet certain requirements, but that doesn't mean that your after school, high school person who's come to work for you is exempt. No, they're going to be covered just the same. They have to be student interns, which have some requirements in terms of maybe school credit, working for the benefit of their education and not for the benefit so much of the employer. Employees who are members of a collective bargaining agreement that was executed prior to January 1st of 2021. People in those bargaining units are exempt through the course of that contract. So whenever that contract ends, it will need to be updated to make sure it complies with the law. So it's up to a 3-year extension perhaps for those individuals. And then finally, independent contractors, they're not covered because of course they're not employees at all. So everyone else is entitled to up to 40 hours of paid time off per year. This 40 hours of paid time off per year is accrued at a minimum rate of 1 hour of leave for 40 hours worked. So there are a couple of things to talk about within that category. First, when we talk about a year, we're talking about a 12-month period of time following the date of hire. So it's a rolling year based on the employee's anniversary date, not your calendar year. A work week is presumed to be 40 hours for salaried employees unless the employer keeps actual records of time worked. That's just a simplification if you're not keeping track. And then the third thing we want to mention is that you can front load leave, so you don't have to worry about tracking hours. That means by front loading on their anniversary date, they would get all 40 hours of the paid leave credited to them, and then they can use it for the next year, subject to the other provisions we'll be talking about. So you can front load them, and that makes it a lot easier sometimes to keep track of it. So when does accrual start? Basically, it starts immediately upon hire. However, an employer may prevent an employee from using this earned paid leave until the employee has been employed for at least 120 calendar days. Now, it doesn't matter how many days in that 120 calendar days they actually work. It's basically a time from the date of hire for that 3-month period or 4-month period. And once that expires, then they're good to go, even if they've only worked, a couple weeks in that period of time. There are a lot of, in the municipal context, there's a lot of times you have a similar provision that says that paid leave can't be used for the first 6 months because that's the probationary period. So all of those types of categories will have to be changed. Yes.
John, we have a question. Can you prorate for those EEs who do not work 40 hours a week?
Well, yes, and it's actually prorated by its very nature. So if you've got an employee who is only working half-time, then you can either track their hours and then they will accrue the paid leave at half the rate. Or if you know that that's their regular working schedule is a half-time, then you can front load them 20 hours.
Thank you.
Okay. Everyone like that answer? Yeah. All right. Okay. Just want to make sure that my friends here are on board.
Still friendly.
That's right. Okay. Let's see. Okay, accrual starts immediately upon hire, and you can prevent the use taking of the leave for 120 calendar days. Usage. Okay, so earned paid leave is not really vacation leave. It's not really sick leave. It's basically earned time off. So it can be used as vacation, for sick leave, personal days, whatever the employee wants. So that has some implications in terms of when you adapt it to your policy, how you want to adapt your policy to account for it. But it's basically leave that can be used however the employee wants. It can be taken in 1-hour increments or smaller, if you allow it to be smaller. But the largest increment you can require is a 1-hour period of time. Employers cannot require an employee to use leave if the employer causes the need for the absence. So if a shift is canceled or if the business is closed for a period of time and the employee is ready to work and available to work, you cannot require that they use this earned paid leave to make up the time. You can do it with other types of leave, their vacation time perhaps, but not the earned paid leave. So there are certain notice requirements which you need to be aware of. There are basically 2 types of situations where an employee may request to take leave. One would be planned leave and the other would be emergency type of leave. So absent an emergency or other sudden necessity for taking earned leave, an employee can be required to provide up to 4 weeks of advance notice of their intent to take leave. You can do less than that if you want, but you have to, you can't ask for them to provide more than 4 weeks of advance notice of taking leave. Now, a lot of times I know some employers will want to have everyone write down their vacation desires for the year on January 1st for the entire year. So that's not going to work for this earned paid leave. You can still do that for your vacation leave, but not for the earned paid leave. Now, for emergencies, illnesses, or other sudden necessity, notice must be reasonable under the circumstances, recognizing, of course, that notice may not be feasible if it's immediately. Employees have to make a good faith effort to provide as much notice as is feasible under the circumstances. Employers can inquire into the general description of the emergency, but they're not allowed to demand evidence. So the person can call up and say, car's broken down, fine, but you can't require them to show the car. Yes.
We have another question. If you could clarify, if an employer has a 6 or 9 month probation period currently, after January 1st, that will have to be changed to reflect the 120 days.
No, your probationary period doesn't have to change, but your policy is saying that you can't take leave until the expiration of the probationary period will have to change. So the person will be able to take earned paid leave after 120 days and still be on probation. So the probation can stay as long as you're allowed to have it. Okay, the employer.
Can we just clarify that? So the 120 days is only for people who, so if somebody has worked for you prior to 1/1/21 and they've already reached the 120 days, then this whole issue is moot and the probationary period doesn't matter. If you hire somebody after 1/1/21, I agree with John, the probationary period is something totally different, and the 120 days is the time during which they cannot use this leave, but they still accrue it. So they start accruing from day one, they just can't use it until 120 days has gone by unless you front load it.
You can't use it regardless of what's front loaded.
Unless you have a policy that they can and that you're front loading it.
Yeah,
You
so
can allow the
yes.
use of the leave. You don't have to stick with the 120 days.
Right. So you can be more liberal, but not less.
So along with that, the next question is, they currently provide earned time to benefit eligible employees. So let's say an employee earns 200 hours per year. Can we designate the first 40 hours of earned leave time used in a year as earned paid leave with a different criteria of use?
Yes, provided it has the correct characteristics, which means that the notice provisions are appropriate for that first 40 hours, and that the accrual provision, it would be appropriate, probably means front loading in that context. So as long as those first 40 hours are properly identified and have the correct characteristics, then you can do that. It's not as simple as it sounds, though, as we've discovered in going through and modifying personnel policies, but theoretically, at least. All right. An employer can have reasonable limits on the scheduling of non-emergency leave. You may deny a particular request for leave for undue hardship. So that means that it would have a significant impact on the operation of the business or impose a significant expense. This is in the determination by the employer, but still it's going to be somewhat of a limitation on your ability to deny a request to use leave. But you can make sure that you don't have everyone taking leave at the same time. You can make sure that you have proper staffing levels, but otherwise you pretty much shouldn't be denying the use of this 40-hour leave. All right, rollover. So an employee has the right to carry over up to 40 hours of accrued paid leave from year to year. So if the person goes all year, they've accrued their 40 hours of paid leave and they don't take any of it, the next year, the whole 40 hours can roll over. However, and this is the fun part, if they carry over the entire 40 hours, then they've reached the 40-hour maximum for the second year, for the rollover year, and they don't accrue any more for that year. So if an employee has used 10 days of their, 10 hours of their 40 hours and 30 rollover, then they're eligible to earn 10 more hours that year. And so that's a good thing to keep in mind. Separation from employment, what happens to earned paid leave? Well, it depends on your policies for the most part. If you have a separate policy on earned paid leave, the policy can either pay out the leave upon separation or it doesn't have to. This is if you have a separate earned paid leave policy. However, if the earned paid leave policy does not allow payout of the leave on separation and the employee returns to your employee within a year, then their earned paid leave gets restored to them. So if you're in a situation where the employee is likely to come back, that could be an accounting headache or it may be fine either way. If you do not have an earned paid leave policy at all, but you have a vacation policy that pays out vacation time upon separation, then earned paid leave will be treated the same as vacation, however you do vacation time. And then finally, if you have front loaded your earned paid leave and an employee uses all of their leave and then quits or separated from employment before they would have finished accruing the earned paid leave, then the difference can be deducted from their final wages. So that's a good thing to have. Yes.
So we have two more questions. What if the EE is a waiter who gets paid $6 an hour plus tips? I assume that would mean I would have to pay them $12 an hour for the 40 hours?
I actually have the answer to that.
Okay, please.
It turns out that that's one of the specific questions that was answered by the Department of Labor in their question and answer. And I don't know that we told you this in the beginning, but in our materials, there's several documents. One is the actual law, one are the regulations, and then there are two different documents from the Department of Labor with question and answers, the original one, and then there's an updated one. And those are actually really helpful. And it happens that there is that very specific question about an employee who has multiple rates of pay, all using the tip credit. And the conclusion from the DOL is that as long as the direct wages and tips received when combined at the end of the week total at least minimum wage, then your base rate of pay is minimum wage.
Thank you. And then the second question is, if we have a PTO policy that states we pay out PTO upon term and they can carry over, do we need to do the same if we create a separate policy for just paid leave employees? In other words, can we treat them differently if it's a separate policy?
Yes, you can treat them differently as long as you comply with the earned paid leave provisions of the statute for your earned paid leave policy. And that starts into some of the integration issues that we've been discovering as we've been revising personnel policies, and I'm going to open up to the floor to see if people have any specific instances of problems they've encountered while trying to integrate these earned paid leave provisions into existing policies. I don't want to take up the entire time, so if there's anyone, otherwise I'll continue. All right.
Well, did you want to address that PTO one, or I can?
Go right ahead.
All right. So the just to clarify, and I think this is John had said this a few minutes ago. You can have a policy distinct to earn paid leave about what happens on termination and payout, and that policy can say anything you want it to say. So you can pay it out, or you can say we're not paying it out. It's only when you don't have a policy at all that it reverts to whatever vacation policy you have, or PTO, arguably PTO. So it's up to you to make a decision about whether you're going to pay it out or you're not going to pay it out, or you're going to be silent about it, which then burdens you to do what you're doing in the event of other paid out time. It's one of the significant things that really needs to be addressed in the policies as you start to go through this. And yeah, I have issues. I mean, these are really difficult to, it sounded like it was pretty easy. Oh, we'll just incorporate this into your handbook and do it before 1/1/21 and everything's good. But it's creating an awful lot of problem, especially for those employers who have separate sick and vacation time policies. Because it's not as easy as just to say, oh, well, the first 40 hours will be designated, we'll just pull it out of one of those, because you're not giving them additional 40 hours. You can count it toward that time. But the problem is you can't require them to tell you the information that you would ordinarily get to determine whether it was sick or vacation time, unless it's a sudden emergency or an illness. So it's not as easy as just saying, well, it doesn't matter for the first 40 hours, we'll just count it toward this.
Yeah.
It really is taking some significant thought and language, playing with the language.
One of the things that I've seen a lot is exactly that, incorporating the notice language. So if somebody already gets more than 40 hours of paid leave in the law, you don't have to give them an additional 40 hours. But what you need to do is you need to make sure that at least for those first 40 hours, you're following the notice provisions here. So let's say they get 120 hours in a year. You don't have to give them anything more, but for the first 40, you need to make sure that you're not requiring more than 4 weeks notice for a planned absence. You need to make sure that you're not requiring anything more than reasonable notice if it's a sudden illness or emergency, and that sort of thing. You can have your normal notice provisions for hours 41 through 120, but you need to think through that to make sure that the first 40 hours comply. And another one that I see is where employees get paid leave on an accrual basis. And usually it works out so that everybody gets more than the 40 hours required by this law. Think through a couple different variations of how you staff to make sure that, okay, under any circumstances, if we don't change this accrual basis here, are there any circumstances where somebody could come out actually earning less than 1 hour for every 40 hours they work? Because if so, you're going to have to update that. If there's no circumstances where that's going to happen, you might be fine, but you need to at least think through that. And then I see a question that says, if our policies documented that you can only get this if you're a benefit eligible employee, is that permissible? No, it's not. So every employee, whether or not they're eligible for any other benefits that you offer, if they're working for you, they are entitled to this earned paid leave law. Even per diem employees, which is absolutely bananas to me, because by definition, they only work when they want to and they have no need for vacations. But the law is very clear. If you're paying people to work, they are covered by this law, so they need to get at least the 40 hours in a year accrued at the rate that John indicated.
So in amending an existing personnel policy to account for these things, you're probably going to need to have a separate EPL policy, if only to address those employees who aren't otherwise eligible for benefits. And that's what I've discovered working with municipalities, is that part-time people are generally not entitled to benefits. So we have to have at least an EPL policy that addresses them because they're not captured anywhere else.
Can I just want to clarify one thing too. We talked a little bit earlier about the 121, I don't know why I keep saying 121. The 120 days which an employee has to be employed before they are entitled to use the leave. And I want to clarify what the DOL said about that. There is no minimum number of hours required that they're working during that 121 days. So it's calendar days, basically, from the date of hire or the date they begin work from you. So during that 120 days, if I'm per diem and I only choose to work one shift, I'm still good after 120 calendar days, no matter how many days or hours I work during that time.
And that's an important point if you have any kind of restriction on the use for initial employees. And I think that in terms of the other provisions, in terms of the notice provisions and all of those extra things that go on, which you might not ordinarily think of when you talk about earned paid leave, I believe I read that the DOL pretty much intended to try to encourage employers to change their leave policies to be consistent with the EPL across the board. And that was one of the reasons for including these provisions, was try to steer people to accepting their paradigm in your policies. Just out of convenience at this point, because you don't want to have different notice provisions for vacation and for sick and for unpaid leave. So they're trying to legislate to some extent your personnel policies.
So the next question is if we give 80 hours, 2 weeks a year for full-time EEs, and they do not use any, they can carry over 40 hours and then only earn an additional 40 hours for the next year. Is that correct?
It depends, I guess, on what you're using.
Yeah.
If you've used all, and employees are going to want to use the EPL first, knowing that if they have some on the books at the end of the year, that they're going to be limited in the following year. So if the employee wants to designate their first hours, the first 40 hours that they use as EPL, then it's not going to be an issue. Your normal carryover will apply for the vacation time and so forth.
I think the employer should be the one designating it as opposed to the employee choosing. My view on this is that for the first 40 hours, you're counting it as EPL so that you're using it up as opposed to the employee making a choice about what they want to use. So I would say in that situation, if they get 80 hours a year and they, what was it again? They have 80 hours, they don't use any of it. So the first 40 would carry over under EPL, and then they would only accrue an additional 40 under your policy.
Yeah. That's the position that I've been taking, is that you can designate your first 40 hours of paid leave will be under this, and then anything after that's covered by our other policies.
To use it up. Well, you're not doing that? Is that?
Well, I think that the regulations are saying that you can't deny EPL to an employee upon request unless there's this undue hardship. So I'm not sure that the employer has the ability to say, no, you're not taking EPL, you're taking your vacation or your sick time now.
No, I
No,
think
we
it's the
said
other
the
way.
opposite.
Okay,
Saying-
that's fine.
Saying you can't use vacation time, you need to use your EPL time
Right.
first.
Right, so and an employee's gonna want to do that,
Right.
knowing that if they don't use up all the 40, they're gonna be restricted in the following year in the amount they can accrue.
Well, maybe, but when you put the policies together, so this is what I've been noticing is that employers who have policies that are extremely generous for sick or vacation, you get people who play these games about, I'm going to use one and not the other because I know one's going to be paid out if I don't use it and the other isn't. So for instance, I designate as much as I can as sick time because I know I'll get my vacation if I don't use it. And I think just having a flat policy that EPL is first, no matter what, because it covers leave for any reason, will get rid of that game, at least for the first 40 hours.
I think that's a great idea.
So I think we're going to probably have a lot of these questions for our question and answer session, but if we can try to get one more in.
That one's way too long. Let's wait on that one.
Okay, so we will come back to that one. What about temp employees that work at my facility but are paid by a temp agency?
That gets complicated.
Good answer.
Oh, time's up.
And that's all the time we have for today.
See you next year.
I think, and I'm sure John and Anne Marie and Brett will correct me if I'm wrong, but I think that gets into whether or not you are considered to be a joint employer of this employee. And if so, you might have independent obligations under this earned paid leave law. If you don't pass the test for being a joint employer, then I think the burden for that would be on the temp employee agency. But that can be a rather complicated analysis that is kind of tough to walk through in the abstract.
I agree.
Probably could use some further clarification because the employee is only entitled to that 40 hours. So would it be 20 hours and 20 hours?
Right.
So 1 minute. All right, we've got 1 minute of earned paid leave left. The last thing we can say is that the Bureau of Labor Standards has the authority to enforce this ordinance, this statute. In addition to other penalties, that there's a specific penalty of up to $1,000 per instance that they can assess for a violation of the earned paid leave law. Each denial of paid leave for each affected employee is a separate violation, so those fines could certainly pile up if you're not complying. But again, it's not something that's enforceable by the employee, it's enforceable by the Bureau of Labor Standards. Employees can just complain to that instead. But so, any final comments or thoughts?
I would just strongly recommend that hopefully you're on your way to having your policy redone, and that you plan on explaining this to people, either just after the first of the year or whenever you have the opportunity to do that, as opposed to just issuing a new policy and not, because people may not, it's going to be confusing as to how this is going to work, and I think it would be helpful to walk people through it.
Excellent. Okay, all right, so you two get to switch the votes.
All right. I will yield the floor. Podium.
So we're moving on now to our first COVID issues section. Like I said in the beginning, we've tried to pick out some issues that are not as commonly discussed, so that we don't just repeat everything you already know. And so along those lines, I think we pretty much decided not to spend a lot of time talking about the provisions of the FFCRA. If you're like the only person on the planet who doesn't know what that means at this point, then you probably don't have to worry about it before the end of the year when it expires. And because most likely anybody who was had it available to them or was eligible for it has probably used it up by now. I think we're all waiting to see whether or not it's going to be renewed as of the first of the year. I would say there's probably a good chance that that's true, but of course we don't know. So rather than spending the time on the provisions of that, we have some other topics that we thought might be useful to talk about. And I'm not going to go, I think they're listed on what you have as the agenda, but I'm not going to go in any particular order. One of the things I think we would want to talk about are how having remote workers impacts wage and hour issues within your business. And since Josh did our wage and hour presentation earlier, I guess I'm going to turn to him to sort of talk a little bit about the issues he's anticipating with wage and hour for people who are working remotely in terms of reporting and overtime and those kinds of things.
Yeah, so this is an interesting issue that is starting to crop up in Maine and around the country. And for your exempt employees, it's perhaps not as big a problem, but for those of you who have non-exempt employees working from home, there are some potential overtime concerns here going on that you're going to want to be aware of and kind of think about as you're allowing people to do this. Of course, the default rule is that if you suffer or permit an employee to work for you, then you have to pay them for that time. And that even extends to time that you didn't explicitly authorize them to work. So I think the best place to start is either with a work at home policy, if you have one. If not, maybe you want one, or at the least a conversation with employees who will be working from home about what the expectations are. And this is vital with non-exempt employees. So I think you start the conversation saying, look, your workday is 9 to 5 or whatever the case may be. And although you will have a computer at home with access to all of your work stuff, we do not want you working outside of those hours unless you're expressly told otherwise. So I think you need to make the expectations very clear up front so that they know that. You also need to make sure that they are aware that they need to track and record all of the time they spend working for you and that they get that to you in a timely manner so that you can make sure that they're paid for all time work. One interesting wage and hour issue that actually came up earlier this year was what happens if an employee, not exempt, is doing emails and stuff like that from work, from home, excuse me, after hours. Do I have to pay them for that? Well, that depends. If they are emailing you as the employer or you're CC'd on those emails, if you have some reason to know that they are doing this, or in fact you told them to do this, then you're going to have to pay for that time. And even in an incident where you didn't tell them to send that email at 10:30 at night, if it's work related and you have knowledge about it, you need to pay them for that. You can discipline them for working outside of authorized hours, but they need to be paid. What the DOL has clarified is that you're not responsible to pay employees for time that was unauthorized and which you had no reasonable reason to know about. So if they are emailing customers and you haven't heard about it, they haven't recorded that time, they haven't told you about it, then you might be able to escape some wage and hour liability there. But I think the big thing is make expectations very clear up front.
Great, okay. John or Brent, do you have anything you want to add to that?
No, I just have a question, really.
Not allowed.
I don't do that, but so if I'm an employer, can I just outright tell the employee, you are not permitted to work after 6 o'clock, and we will not pay you for any work after 6 o'clock?
You can tell them that,
But
it won't be enforceable.
if-
So
if
you
that's
can
how
give-
know they do, and
Yeah. You can give clear directions, do not work after 6 o'clock. If they work after 6 o'clock and you know about it, you need to pay them for that time. You can fire them. You can fire them, you can discipline them, whatever, for breaking your rules, but you still need to pay them for that time, even if it was unauthorized.
And I've been telling people something similar to that as well, that if they violate a policy about working when they're not supposed to be working and not having approved overtime, that they can discipline. I've yet to see it happen.
Yeah.
Well, the other place that comes into play though is the workers' comp, and I'm going to talk about that in a few minutes, but one of the ways, obviously we're having a lot of issues with remote workers and whether or not things that happen to them while they're at home are work related or not. And this has long been an issue with telecommuters. And one of the factors we always look at is, was the employee on paid time or not when they were at home getting their coffee and they tripped over the dog or whatever happened. And so having somebody be accountable for a set period of time, and this is when I'm working and this is when I'm not, is actually helpful in defending a potential comp claim as well. All right, so let's change gears for a second, and let me ask about face masks. So we're all wearing them. We know the governor has given the order that everybody should be wearing them. But what about you haven't, and I'm certain everybody on the call has dealt with this in one way or another, but what happens when you have an employee who doesn't want to wear one and says it's because of a medical situation? John or Brent, do you guys want to take this?
You have to accommodate them if you can.
Ventriloquist. Well done. I'm the dummy here. I agree with that, but I was going to say something in preface. As I read the governor's order, it's not, let me back up a little bit. Until the governor's recent order, my understanding was, at least on the OSHA side, because I did look this up last week before the order, is that OSHA just generally recommended that as the default, employers encourage employees to wear face masks at work. But as I read the governor's order as it applies to Maine, it's that if it's a public setting, which is defined very broadly, people are required to wear the mask. And so, and my colleagues will tell me if I'm wrong here, but if an employee, not for health purposes, but for some other purpose, refuses to wear the mask, they are violating a law of the state of Maine and presumably can be disciplined for that, at least in theory. But I definitely agree that if the reason for not wearing the mask has to do with, for example, they have asthma or COPD or some other condition, then you're in the ADA world of seeking a reasonable accommodation. And you may be also in a position, though, of the direct threat analysis as to whether or not the employee poses a direct threat to himself or others in the workplace, in which case there might not be a reasonable accommodation, but that's where you're at. You have to make an individualized assessment and think it through, in my opinion.
And go ahead.
There's always an accommodation available, well, not always, but usually there's a combination available of remote working if all else fails. Now, that's not appropriate for all employees, but if worse comes to worse, then that it often works.
And you can also look at those clear face masks that don't go over somebody's face. You can look at segregating them in the office. There are multiple ways that you can, try to address that situation and keep people safe.
And one thing to be, I mean, there's so many things raised by this, it's hard to know where to go first, but one thing in particular is about the nature of the face mask. So as an employer, of course, you have the general duty under OSHA to ensure as safe a workplace as you can. And so we were talking about the CDC's recent, whatever it is, a guidance or something that said that those, what do you call those things?
Vent things?
The what?
You're talking about the vent? They got-
The N95s?
No, the thing that you wear, like skiers wear.
Oh, yeah, the buffs.
A buff.
Oh.
That a buff is not effective like a face mask is. And so, in terms of finding a reasonable accommodation, as an employer, you need to be aware, you wouldn't want to make a recommendation to somebody to wear something in the alternative that turns out not to be, effective in preventing the spread. And that's, partially your duty to do.
It's also interesting to note that recently they're saying that face masks do have some protective properties for the wearer as well as for other people. For a long time they were saying that face masks are good for protecting other people from you, but did nothing for you. And now they're backing off that and saying that there may be some protective properties and that could impact some analyses.
Now, Brent, when you mentioned the governor's order, you said not wearing it would be a violation of law. And I want to talk about that because there's been a lot of stuff in the news. In fact, there's a news article today in which the governor was talking about people still refusing to wear the masks and what that means for an employer. So just to be clear, it's an order, it's an executive order, right? It's not a law. And so the issue comes up with, for me, the first issue is for an employer, it's a matter of best practice, right? So even if you want to argue it's not a law, we don't have to comply with it. What I would not want to be faced with if the CDC were to come in, or OSHA, is to not be able to say we did everything we could have possibly have done to prevent this exposure, right? So I think, when you're talking about, are we going to require them? Are we not going to require them? Is it public spaces? Is it not? I think that's it's got to be part of the analysis, right?
Yeah, and executive orders are enforceable. So it's just unlikely that it would be.
Right. No, I didn't mean, I just meant it's not, just to clarify, it's not a law as opposed to being an executive order. But the governor did talk today in the newspaper about not putting employees on the front lines to enforce it. And we'll get into that when we talk about policies and workers' comp and stuff.
Henry, we have a question. What if face masks have offensive images or language?
I love it. I'm so glad somebody asked that.
Yeah.
You mean like this one?
Yeah.
Well, okay, so somebody take the offensive issue.
Right?
Well,
I'll take it.
well,
I think
It's fitting for him to do.
as a Patriots fan, I do find that offensive, by the way.
Who won?
It depends to an extent on what the offensive stuff is and what setting you're in, but generally speaking, you don't have to allow somebody to come in and violate your general workplace dress policy just because it's on a face mask as opposed to a t-shirt. It might change a little bit if you think it's a MAGA mask and that offends you, and that's what it's offensive, and you're working for a municipality, then it gets a little bit more tricky there to kind of think through what the implications are there. But generally in the private sector, and if it truly is something obscene or graphic or whatever, you don't have to permit that.
The employer can provide a box of paper masks and say, take your mask when you go to work, and that's what you wear.
Well, again, I think it's a matter of clarification for people too, because I had an employer call in a couple of weeks ago when the pre-election stuff had really heated up, and said, I've got one employee wearing a face mask that said Black Lives Matter, and the very next day another employee came in with a face mask with a Confederate flag on it. So in order to anticipate those kinds of things, you may want to consider just a flat out policy like clothing or whatever else, no images, no words, no any of that stuff, and then you get rid of that problem completely. Because they run the gamut from, there's pretty much everything on face masks at this point. Yes.
And then another one, what about an employee who has a concealed carry license and legally carries at work? they should not have their face covered. Does that create an exempt status?
Ooh.
Is there,
That's an interesting question. So, I guess I could take that unless somebody else wants to. It makes me a little uneasy thinking about masked armed people running around, generally. I'm not aware, if you're a private employer, I'm not aware of any law or requirement that says you have to allow people to conceal carry within your place of business, number one. There is a law that says if they're a concealed carry permit holder, they might have a right to keep their firearm in their locked vehicle out of view, which is different, but I don't believe, unless I'm wrong, somebody tell me otherwise, I don't believe you have to allow them in your place of business with that. And like I said, when you couple that with face masks, it becomes an interesting proposition, let's say that.
A lot of
But maybe
things have
for-
changed. I mean, a year ago, I wouldn't have considered walking into a bank wearing a mask. And now, you know, they get mad if you don't. So, you know.
well, but for a municipality, for instance, a sheriff's department, I mean, they would have the ability to carry a concealed weapon. I don't know of any law that addresses a correlation between a concealed weapon and a mask, though. Is that, were they specific about, is that a rule or a requirement?
Yeah,
They weren't specific, so.
So if whoever wrote that wants to clarify, maybe we can try and address it.
We could look it up at lunch.
Yeah.
I'm going to ask.
Is there more? Yeah.
So somebody has asked, is it considered a reasonable accommodation under ADA if an employee requests to work 100% from home due to COVID-related stress? Doctor has indicated that they need to receive mental health treatment due to COVID stress so that they are completely off, or so that they are out completely on FMLA currently, and the employee has already inquired about working from home 100% of the time upon their return from FMLA leave in January because of COVID stress. Do we have to accommodate this because of ADA?
let me begin the discussion because in preparation for this, I looked a little bit, and not surprising, the issue of whether or not COVID-related illness or COVID itself is a disability under either the federal ADA and not to my knowledge that it's been adjudicated at all under Maine Human Rights Act. There, it's a little bit reminiscent, and I'm not comparing the two other than just saying a little reminiscent of when HIV in the 80s, the question was, well, is HIV automatically a disability? And the United States Supreme Court said, no, it's not. Now, since then, under the Maine statute, as you may know, there's just a list of things that automatically qualify as disability, but COVID hasn't made that list yet. So the first question out of the starting gate is this COVID-related stress suffered by this person a disability under the Maine Human Rights Act to begin with? And if it's not, then you don't have to accommodate it. And so it's not on the list. It's, I think, what, expected to last more than 6 months. Is that the thing? And it affects your life in a bad way. I don't know. You know, the pandemic is going to last. So maybe the answer is this stress-related problem from COVID does amount to a disability, and maybe you do have to start thinking about whether or not there's a reasonable accommodation that wouldn't be an undue burden, that yada, yada, yada.
So I have a couple things to add to that. I don't know that maybe you need to look at it more broadly and take out COVID and just look at it as an anxiety condition,
Right.
because anxiety
Well, that's
certainly
what
can
that
be a
seems to be.
disability.
Right.
So regardless of the reason for the anxiety, I think I guess the way I would assess that is the anxiety itself a qualifying disability, regardless of what's causing it? And if it is, then I agree, you then have to work toward finding a reasonable accommodation if there is one. Now, one of the things that I wanted us to talk about is this whole issue of telecommuting, because a lot of times before the pandemic hit, employers were well well within their rights to refuse requests for people to work from home if there was any reason why they should be in the office, or it was just better to be in the office. And I think my experience was the EEOC was fairly liberal toward employers to say, no, if you say they need to be in the office, then they do. What we've seen though is that now that so many people are remote, you have to reevaluate whether that's actually true anymore, right? You guys seeing that too?
Absolutely.
So that if you've allowed somebody to work remotely to benefit you during this COVID thing, that to now just come back and say, no, that's not going to be a reasonable accommodation. The EEOC has actually published some stuff saying we frown on that. So my answer to this person would be, when the FMLA ends, number one, does it renew as of the first of the year? And you'll have to deal with that situation, or is it a rolling method? And number two, if it doesn't renew, I do think you have to go through a reasonable accommodation analysis, but I think you'd be entitled to information from their doctor about the nature of the disability and why the necessity to be at home, which seems fairly obvious.
Yeah. Can I ask a hypothetical and see what everybody thinks about it? This is a situation I've come across, and I'm sure others have too. What happens if, let's say, we have an employee who has some underlying medical condition, COPD or something along those lines, and they have, let's assume that they really can't work from home. Because of the nature of their position, they are just not able to work remotely. And they get a note from their doctor saying, this employee, because of the risks that they would, because of their underlying health condition, the risk that they might get severe implications from COVID-19, they just cannot go to work until the pandemic is over. How do we analyze that?
Did you want to go?
Well, I mean, certainly under the old standard FMLA, that's not going to be very helpful, but under the regulations that are in place at the end of the year, I think then they are going to be entitled to FMLA leave. You're looking at me. You've got that look.
You mean FMLA? Are you talking about the EPL leave or
No,
FMLA
no.
or ADA? I don't know if I'm maybe
All right.
misheard you.
I was talking about FMLA.
Okay. All right.
But after the first of the year, we don't know what's going to happen with that. If a person's out of work for a COVID-related concern, even though they don't actually have it, the question is the current FMLA standards going to allow them to take FMLA time for that?
You mean the FMLA under the FFCRA?
Yes.
Okay. Yeah, I mean, I agree. That's certainly part of the analysis. I guess one of the things that concerns me about the state of the world and what employers are doing is, the first place I would start with that employer is, what are they actually doing for a job? Because a lot of people aren't doing what they used to do. And if their job duties have changed to the point where maybe now they could be accommodated, then that's an issue. But if you've got somebody who's got major performance problems and tardinesses, and I mean, I think you're within your rights to deny an accommodation if you can show that there are objective reasons why. On the other hand, I mean, I don't know, everything seems so broad that maybe you don't have to try it and give them an opportunity.
Let me add this to the hypothetical, which to my knowledge, we did not.
We just made it up.
Just made up.
So the person has
Sorry.
COPD, which in my mind is a disability under federal and state law pretty easily. Significant breathing problems. And their request for accommodation is, I just want leave until a vaccine or the end of the pandemic.
Yeah.
And I've been reading articles that say that maybe vaccine by April or something like that. So employer, that is what I want, is a reasonable accommodation. What sayeth you? Depends, I guess, on the what the employee does, size of the employer, hardship to the employer, et cetera, et cetera.
Yeah.
But it's not an actual disability that would be preventing the person from working. It's a potential exposure. So there is no, the request for accommodation is not based on an existing
So you're saying that person with COPD whose doctor says it's too big of a risk to be there, who's not performing the essential functions of the job, it's not really because of the disability.
No, it's because of the concern of something else happening. I mean, it's really no different. That person may be more at risk, but other employees have a risk of coming down with the illness and getting very sick as well. So it's just a matter of degree. But right now, sitting before you, they have no condition.
I actually think the DOL or the EEOC has issued an opinion consistent with what you just said, which is that fear of getting something is not the same thing as having a disability. Unless it's yeah.
So maybe the moral of the story is to call us if that happens.
And we'll debate it.
Well, I
Oh,
can't,
all right, 5 minutes. Okay.
my gut's telling me a little different, but that's why we're here.
All right, so what I'm gonna do is I'm gonna leave workers' comp for the next one, and I just wanna ask my fellow panelists about this whole social media thing, because I know that you're dealing with it. And by that, I mean, what does an employer do when all of a sudden they get 25 or 40 emails in a morning saying, I saw a so-and-so employee at the rally for whoever was here, and there's a picture of them in the paper and they're not wearing a mask. Does an employer have to, what do? They have to do anything?
Well, I'll say something.
Please
Um,
do.
as much as it pains me, I don't think that there's enough evidence and knowledge to support it, the idea that just because somebody was in rallies politically, but whatever it was, wherever they were, in a group of people without a mask, I don't think that's enough to support the idea that they're really posing a significant risk to fellow employees.
But what if that
Yeah.
action violates one of the governor's current orders? You and I talked about this.
Well, then-
Employer policy.
Or, right,
Or an employer policy, well, or the order, then I think they can be disciplined. Because I do think executive orders, I think we get tripped up on what's a law, what's not a law. It definitely has the force of law, whatever, and I think there may well be some interesting academic, maybe they're already being written right now as to what exactly are executive orders, but they are enforceable by the full weight of the administrative structure, the agency structure in the state. So,
But I don't think it's necessarily discipline. If you're telling this person, you now have to work remotely if you can for 2 weeks, it's not necessarily disciplinary action taken against the person. It could be a reasonable direction to the employee.
although it could be, right? I mean, if you've got somebody out there who's purposely violating an order that's in place, and now you've got employees saying, why should I have to work around somebody who's violating an order and potentially putting all of us at risk? Couldn't that be grounds for?
I think it
discipline?
could be as well, but it doesn't have to be. If you're asking this person who has no symptoms, but has been seen out in public without a mask to now work from home for 2 weeks, there's nothing necessarily disciplinary about that. You could just say, just go home and work.
but it's hard, and maybe I'm just not seeing it though. What law would the employer be violating in terms of that employee's rights if the employer said, no, you guys stay home?
And that's your
For a
public
couple of
sector.
days.
I agree. Public sector might have other issues, but constitutional.
And of course, assuming, of course, that you're not just doing it for women or,
Uh-huh.
Yeah.
So
or
that's the next thing.
this or
Somebody
that
goes
or
to the
whatever.
Trump rally and you do that, and then somebody goes to a rally for the Girl Scouts
Yeah.
and you don't do it, what happens then?
Well, private employer though can, which you almost would never do for any, but it's not a protected category, Republican, Democrat, Libertarian, right? I can fire somebody for being a Libertarian
Is that necessarily gonna prevent
or
someone
a
from bringing a
socialist
suit?
or whatever. Well, I just,
No.
I would say the best practice would be to make sure that you're applying that rule consistently,
That's
regardless of why the
Yeah.
person is out in public doing
Right.
these things. If they're not following the rules and regulations from Governor Mills or whatever, treat them all the same.
always a good.
Excellent advice.
And the question on that is, even if the person in this example is not on the clock or company property.
Doesn't matter.
Doesn't matter.
I think especially in this extreme situation.
Yeah.
But again, as you're amending your policies, which we're going to talk about in the next session, you may want to consider talking about off-duty conduct, which maybe you've never, tried to mandate before. So I think with that, we are at the end of our time for this session. And so we're going to take a lunch break until 12:45, and we'll be back with COVID Part 2. So what I thought I'd do with the policy change.
All right,
is go
it's
around
all-
and ask all of you to.
Go for it.
Oh, we're all, well, hello. So we're back, and we're back for COVID issues part 2. And I just have to show you. So Mark is awesome, and he gave me, everybody took sympathy on me for that stupid smelly face mask. And now I have flamingos with Santa hats on them. So there you go.
And I'm jealous.
Okay, so in this session, we had a couple of things to talk about. I know there's been an awful lot of questions. We are going to get to them, but in the last session, the last hour, and because I'm afraid if we do them all now, we'll use up all our time. So I had promised talking about workers' comp. I'm going to touch on it now, and then we can do it in the larger session with issues about telecommuters. But in terms of COVID, you all know that there's a possibility that someone who contracts the illness might make a claim that it's work-related. We haven't, frankly, seen too many of these yet, or at least I haven't. I have one working its way through the system. I don't know if it's going to be the first one to be decided. It's possible that it will be. I know some of the healthcare providers are paying if somebody was actually in close contact with somebody who had it in a healthcare setting. But overall, the question is going to be the same as it is for any other claimed injury, and that is, did the injury arise out of it in the course of employment? One of the things that's interesting about that is when is there actually an injury? Because there is a case from a long time ago that says that an exposure without symptoms, without anything else, is not an injury. So that was about asbestos. And that's kind of true of COVID. If somebody is exposed to somebody who has COVID but hasn't developed any symptoms and hasn't tested positive, then there is no injury yet. So that's an issue as well. And then overall, it's just a matter of how would the employee prove that they contracted it at your place of employment. Good God, I can't. And contracted it at your place of employment as opposed to anywhere else they might have been. I do want to tell you about a very interesting twist in this current case that I have. This is not going to happen very often, but it puts a really interesting component to it, and that is that the employee said that they contracted it at the place of employment, to which we promptly responded, no. And so then he's made an allegation that he was in a room the employer designated as the prayer area, and the person who'd been in that room before him turned out to be a known case of COVID. And so he's making an argument that there's more of a connection there. I actually think it's a super interesting argument, and probably will be more, put it further down the line toward work-related than not, although I'm not in any way saying it is. So at any rate, in terms of comp and COVID, that's mostly what we're looking at. There is no presumption in Maine. Some other states have created a presumption. Maine has done that for cancer and some other conditions, but there is not one yet for COVID. So that's pretty much all there is to say about that at this point. Now, two of the big things we want to talk about in this session were violence and recommended policy changes. So let's start with violence, because that was one of the things the governor addressed in that article in the PDN this morning, in saying, and actually this gets into a component of comp too, saying that employees, sort of low-level minimum wage employees, should not be the people who are having to enforce this ordinance about wearing a mask for patrons or customers who are not happy about it. And I think that's exactly right. I mean, have you guys written policies about violence or addressed this yet at all?
I have not.
I haven't.
Well, what do you think?
I think that's right.
Yeah, I have not had to address it, thankfully, but I agree that your rank and file should not be put in that position. I think it would be best if you could have one designated person of management or one per shift or something along those lines to be the person to address it so that they're trained on how to do it and they're providing a consistent message to people.
So it's a tough nut to crack because, you know, again, this analogy I'm not suggesting it holds water, but you know, you think about other areas and I think about nightclubs and they have a bouncer at the door. And if you don't have the right ID, then the bouncer doesn't let you in. But I couldn't imagine a situation where, well, of course, I couldn't imagine the pandemic a year ago, but you know, maybe someday we'll go to retail place and there'll be a bouncer at the door with a manager and they'll just politely say, no, you can't come in.
And some places do have an employee station out there to make sure, or at least to offer masks, but a lot of smaller employers, especially retail ones, have the problem of having small workforces and not being able to spare a person and not wanting to tell customers they have to turn away. I have seen it happen before where a person went in without a mask and came right back out because they weren't welcome without a mask. But a lot of small retail employers are unwilling to do that, and I can understand why.
I saw a sign at a small retail establishment that said that I just personally thought was sort of clever, that said, you have to have a mask to come in here, and if you don't like it, please just turn around and leave.
Mhm.
I mean, I think from an employment law perspective, it makes a lot of sense to me to have somebody in management who's designated to be the person who says that to people. Because, you know, I worry that somebody, you know, somebody who's not as sophisticated might be more inclined to engage in some violent behavior with somebody who seems to be headed in that direction. And the other thing, I know some of my employers have done this, and that is that the police, I believe, will come in and do sort of a how to talk people down training. And I think that's a great idea for employers who are large and, you know, have multiple issues like this and a lot of situations. And so I encourage people to do that. One thing I think is true is that if you have somebody violate the mask ordinance, you can't just call the police and say, come deal with the situation, right? Unless it becomes some kind of violent situation, I don't think calling them is what you need to do.
I have had a couple other related questions come up to this that I'll share just in case they're useful. A question I've been asked a number of times: if you're a private place of business, no, somebody does not have a First Amendment right to come into your place without a mask. That's nowhere in the Constitution. And also, if you're a private employer, no, you are not violating HIPAA by telling somebody that they need to wear a mask, and if they're not wearing a mask, saying, is there a reason you're not wearing a mask? That's not a HIPAA violation. And so just to clear that up, because I've gotten that one a few times on both those.
One of the medical issues that I have seen in wearing masks, and this can be from a customer or it could be from an employee who works for you, is that there are people who may be hearing impaired, who cannot, who operate by reading lips and watching your facial expressions in your mouth. And so they're unable to communicate in the event everybody's wearing a mask. And so that, has anybody had that particular situation come up?
Yeah, I've had it come up because I can't hear, especially behind those plexiglass shieldings and the person's back there.
But yours is just because you're old.
2 weeks younger.
We're exactly the same age, so I'm good. And he's not an employee, so I'm okay. Don't send me nasty messages.
John, what?
I don't know what you're talking about.
All right, so as we move from this topic into, because it sort of lends itself to the next thing, which is policies. So what I thought I would do is maybe each of us could talk about a different policy that may need to be changed or amended or created this year from a handbook based on COVID related things. And I have a whole massive list of them if you guys can't think of any, but how about Brandon, what kind of policy?
Nothing that we haven't touched on, so go ahead.
Okay. All right, Josh, was there any?
I think, especially if you're transitioning to a remote workforce, I think it makes sense to have a work at home policy if you don't have one, or if you do have one, to take just another look at it to make sure that it works with what you've got going on at the present time.
I will say one thing, and I'm not sure, there's most workplace policies are conceptualized more as the stick than the carrot. And it may be appropriate in some instances to encourage safe workplace behavior with carrots a little bit than the stick, but of course, depending upon the facts and the circumstances, that can get into trouble and yada yada, but it doesn't always have to be the stick.
Yes, it does.
Well, you're a mother, that's
Well, I think that-
John, does it always have to be the stick?
It doesn't, what did you say? I think everybody at this point needs to have a contingency plan for COVID exposures. I mean, that's a
Yeah.
policy that needs
Yeah.
to be, you need to know what you're gonna do when it arrives.
Yep, happens like that.
Yeah.
I mean,
Yeah.
and that's true, because not only is it the right thing to do, and you need to know immediately how to respond, but you need to meet your obligations, right, under OSHA's general duty.
Right.
And the only way to do that is to show that you have prepared for this and you have a procedure in place. It may not be perfect, and I was just working on ours yesterday, and there may be things that have to be changed and amended as you go on. I mean, every day,
Yeah.
right, this whole situation
Yeah.
changes and you may have to redo it. But that's certainly something that you need. In terms of a general handbook, though, I would recommend taking your handbook and going through it page by page and thinking, is there anything about this policy that I need to revise that has changed because people are remote or because the way my workplace is operating? Like, for instance, what about trainings? Right, so most employers are still doing a sexual harassment training, for instance, yearly, even though they might not absolutely have to. How do you figure out how to do those? And what about dissemination of like the posters? Because you all know that all the posters have to be posted somewhere. And now you heard about the new regulation of employment poster, and there's the new minimum wage poster. And it's your obligation to communicate those to the employees. So what do you do about that? Answer.
Was that a question?
Yeah. That was actually a question.
I thought you were just.
To any of the panel.
All right, well, then I think you need to give it to them.
Yeah. I think you, go ahead.
Something fell apart at lunch.
I think you post it in the workplace just as you normally would. Even if you don't have people in, I think you just put it there. But then I think you also need to find a way to get that to people who are working remotely, whether it's through an email, through paper mail, whatever your preference is, but get it to them in one form or another.
And
And
it's
have them
actually,
acknowledge receipt if it's by email.
it's actually easier if people are working remotely to make sure that they're getting it, because you have all the procedures in place for sending them paperwork and emails, and you know that they're set up because they're responding to your work emails. So it's actually easier, I think, to get it to them.
I think that's right. You just have to remember to do it, because if you have people who are not reporting in, well, and that raises a question in terms of this broad telecommuting policies, what we used to call it, now remote worker or whatever. I mean, that and many other things have to be dealt with, like how often somebody comes to the workplace, how often they're expected to report back, what do they do about machinery, and who's responsible for setting that up, right? Because you've got workspace issues. What about liability for, if somebody visits me because I'm working and I need somebody to deliver something and they trip and fall on my front porch?
Yeah, so that's something I think it's best, if you're going to have a policy or a work at home arrangement, to make sure that the person has a defined area where they're going to be working out of primarily within their home, whether it's an office or a bedroom or the case may be. And that's their workspace. And then if, the FedEx guy trips on the front porch, I don't think that's necessarily an employment liability. But then if you let the FedEx guy into your home office and he trips over your printer, that might be a different situation. So those are the sorts of parameters I think that you should, walk through.
Of course, if the FedEx guy is only there delivering work product to you, because and it wouldn't otherwise come to your house, then maybe it is. Maybe there's some sort of indemnification provisions in your policy that will cover that, in which case.
One of the
Get more
different
insurance.
hats I wear is through the years, and even now, I've been doing quite a bit of insurance coverage work? And I don't know the answer, but that just rang a big bell in my head that it might be a good idea to look at the exclusions in standard homeowners and commercial general liability policies to see how and if they apply in just like situations you just mentioned.
Which should be part of the overall telecommuting. I mean, I'm a huge proponent of having this in writing in some form of agreement where, I mean, Josh talked earlier about when somebody's going to be working, what the parameters are on timing and all that. I think it's very important to have the set workspace, right? And you need to have policies about who's using the computer and who's not, so that your 8-year-old doesn't pick up your computer and go flying around the house and, you know, trip over the dog and then the computer's dead. And then, so one of the interesting things always, not just in telecommuting situations, but is to collect property from somebody when they terminate, right? So how is that affected? If you've got remote people and you've given them this huge, big setup at home, what do you do when they terminate and say, don't come in my house?
You go to their house before you terminate them, right, and ask for their stuff, and then you tell them the news.
You say you're gonna get an award.
You give them the fake carrot.
Okay, before we have a question, is there an actual answer?
Well, make sure
one
you
actual
document what
answer is-
property you've given them,
Right,
Yeah.
so you know what
Yeah.
they have.
right.
Because what can you absolutely not do?
Break in.
Well, that's right.
You can't deduct,
You can't deduct.
right,
Oh, right.
from a final paycheck
Right.
for equipment unless maybe it's a loan, right? You have them sign the document, although I'm
Yeah,
iffy
that's
about
true.
that.
That gets very iffy.
Yeah.
So yeah, don't go deducting out of paychecks. But I think, like John said, have documentation in place beforehand. We gave you machinery A through C, and then, you know, it's going to be awkward and an uncomfortable situation one way or another. But you know, I think you got to meet them somewhere to deliver the news and get the stuff back.
That is, through the years, it's, I've seen as a practical matter, that is one of the practically difficult things that occurs, employers trying to get their property back, and or on the other hand, employees wanting to come into the office to get their stuff and not showing up, or the other employees being uncomfortable, and it's just, it is an issue logistically.
And the more you deal with it up front, probably the better off you're going to be, although you can have a policy saying you got to give it back and they might still not.
For what it's worth, in many employment contracts, if you have one, there are specific provisions that say when you're no longer employed, you absolutely have to return all the property, yada, yada, yada. That can help, but
I mean, there may be situations where you have to go as far as get the police involved, right? To go out to the house and get what's your
Yep.
property. But you would need to have a very specific definition of what's yours and what's theirs, so that there's no question about that. Now, here's a policy that I was particularly intrigued by that I think, well, now that I thought about it, it seemed like a pretty good idea, although I had to think whether or not there was anything wrong with it, and that is a policy on children and not allowing children in work areas or in the office, because many of you, when we were in the same situation, school is remote, what do you do with them when you're trying to work as well? And I've even seen policies that say when you're working at home, this is not daycare. This is not, you can't be a worker and a teacher at the same time.
Well, that's one thing to say, that there has to be a caregiver there while you're working. Another one, quite another thing to say that they can't come physically into the room. I mean, that seems fairly unenforceable.
And yet appealing.
Yeah.
Sorry. All right, Karen, did you say we had a question?
It was just somebody,
Maybe we should do that.
somebody was saying that it feels similar to having someone use their personal car for business use. They must have insurance, their car must be in working order, etc. So that the similarity there.
You mean in terms of tripping and falling on the
Yeah.
whatnot? Yeah, they're
Yeah.
all nodding.
Yep, I agree.
So probably yes. Okay, so let me, let's see, other policy changes. Well, what I would, like I said, I would generally recommend that you go through your handbook, pretty much section by section, and see what else needs to be addressed, because for instance, what about dress codes? That's all totally changed now, right? You've got people at remote. You have to figure out what are we going to try and enforce and what are we not, but yet you need to make sure at least you've got some level of professionalism when people are on Zoom, right? So that policy would be worth looking at depending on what it currently provides for.
The background noises on the phone as well.
And even things like the background screen, right? When somebody's doing Zoom meetings, despite John's request, maybe it's not appropriate to have a beach and island scene because you don't find that professional. That's totally up to you, but you need to set those rules if you choose to have them. The other thing I would look at, of course, we've already talked about this in the context of the EPL leave, is your general attendance and calling out policies. And because maybe that's different when somebody's working at home. And I think you probably need to think through what kind of notice do you need to have? Has it affected vacation time?
Certainly. Yes.
Oh my
Yeah.
God. Okay.
Yeah, I think that you definitely want to give that some thought, right? I think even with a work at home situation, you still want to have some sort of reporting mechanism in place. If people are either going to be delayed in starting their day or not being able to work at all, because you as the employer kind of need to know logistically who's working for you, what they're doing, when they're doing it, that sort of thing, to keep track of people, for lack of a better term.
Right.
You might expect attendance issues to actually be reduced in this situation, but maybe not.
Well, that's the thing. I mean, what about when someone, we all deal with snow days in the office, and periodically people say, I can't come because my kid's out of school today, or I can't come because I can't get out of the driveway. Those are things you may want to anticipate and say, it's not an excuse anymore, right? Because you're already at home.
Unless you don't have a caregiver to watch after the child, because your policy says you have to be working.
Yeah. Right. Okay, and oh geez, I just thought of something I wanted to bring up, and now I can't. Let me think about it while we see. Is there a question that we can answer while I think about what I was trying to remember?
If you work in an environment where each person has their own office, is it required to wear a mask during all work hours, or only when going into public areas, like a lobby, bathroom, supply area, kitchen, breakout room?
Well, that's got a lot of elements to it. Somebody wants
So
to
Go ahead.
I was gonna say, I'll give my best practices thought about it. Brent is more up to speed on the actual language of the governor's latest order than I am.
It just means I obsess about it more.
I think that if somebody is in an office where they have the ability to close the door and they're in there alone, it's fine for them to take their mask off. But if somebody else is going to be coming into that office, both ought to be wearing masks. And certainly if the person's going to be leaving their office to go to other areas within the building, they ought to have a mask on at that time as well.
That is exactly my understanding of the intent of the order, and also just what best practice would be.
But that doesn't mean that the employer can't mandate that you have it on all the
Right.
time.
Right.
Correct,
And-
correct.
Yeah.
Now, one thing that we recently did, and I would recommend everybody considering doing this as well, in terms of COVID exposures, you know that the CDC has amended the definition of what a close contact is, and that's imperative for your employees to understand, because if there came a point where there was an exposure in your office, you're going to need to ask the person who is exposed, with whom did you come into close, or with who are you within close contact with? And it's important that people know that definition ahead of time so that they're then able to think through, well, I was here on Friday and this is what I did, and so these are the people that I would, that would meet that definition. And that's true regardless of masks at all. That masks don't come into play in terms of the contact tracing.
Well, and frankly, I don't think you want the employee trying to apply that definition. I want the employee to give you all the contacts and say how long they're with that person. And then you as the management or employer can then say, well, this doesn't qualify. But I don't think you want the employee trying to apply that.
No, but what I'm saying is, if I know ahead of time that close contact means within 6 feet for 15 minutes over a period of time, that gives me a better place to start than if I tell you every single person that I saw 20 feet down the hallway on any
Right,
particular
well,
day.
certainly the 6 feet part is important.
Yeah.
but
So I would consider doing that. Now, I remember what I was going to ask, and that is performance evaluations. What do you, I've heard varying things about, we're going to delay them because people aren't at work. We're going to delay them because the jobs are all messed up and nobody knows what they're doing. Because now it's we're sort of coming to the end of the year when people normally do these.
I haven't dealt with any situations where an employer has decided not to go forward with a performance evaluation. And my thought is that if you're coming up on a regularly scheduled one, I think it makes sense to go ahead with it. You might be in a position where you need to give some consideration to the fact that, yes, things have changed over the course of the year. So maybe this person didn't hit their production quota, but maybe there's a really good reason for that. So you take that into consideration about how the dynamics have changed. But my thought would be to go ahead with it just as scheduled.
I think that makes sense to go ahead with this schedule with the caveat that there may be things that you are unable to evaluate. And it may be that when people do return in person, that you will have to work on some bad habits that may have been acquired over the past year.
Well, and by the same token, what about job descriptions? Because a lot of what people are doing at home doesn't really match up with what they were doing when they left.
I would take a bit more of a wait and see attitude before amending a job description though. Because if things are going to change in the next 6 months, I hate to have modified the job description and then have to go back and redo it.
Right.
I mean, the basic essential functions are going to be the same, most likely in either situation.
Maybe, but if they're
Maybe.
not, then maybe that's a reason to do it. I mean, if it's totally different.
I think it has to, I think
flexibility is
flexibility
going to be
good.
important.
Yeah,
In terms of recognizing that, okay, we asked you to do tasks A through E on your job description, but because you were remote, you couldn't do A through E, so we shifted and asked you to do F through I, and you did those pretty well. I mean, I think that's the type of flexibility that you need to be able to have in doing these evaluations. But that's not to say you're permanently going to change their job description going forward. Maybe you will, maybe you won't, but you don't necessarily need to decide that right now at the time of the evaluation.
Right, because that drives how you do the performance evaluation, right? Based
Right.
on what they're actually now doing. And also, you've got the whole Maine Human Rights Commission issue, because oftentimes if there's a disability discrimination claim, the first thing the commission's going to ask you for is the job description if you're saying I can't reasonably accommodate. So you've got to make sure it matches up, with what the person's actually doing.
Right.
Okay, now one of the things that we did not touch on in our last session was leave. And I know, of course, we've talked about so many forms of leave now, it's mind-boggling. But the one that we haven't talked about is the caregiver leave law update. And it doesn't come up very often, but it has come up now because it is absolutely relevant, according to the DOL, to people who need leave for covered reasons that maybe are no longer, the FFCRA is no longer available, or they weren't qualified for it to begin with. And so just to give you some background, in case you've never heard of this before, it's a Maine law. It's called Maine's Employment Leave for Caregivers and Persons Affected by Extreme Public Health Emergency. And it basically requires an employer to grant reasonable and necessary paid or unpaid leave for a variety of reasons relating to a public health emergency. So it has applied. First of all, have any of you guys actually seen this law applied or had it come up? Okay. So the reason that it's come up for me is because number one, we had an employee who was no longer eligible for FFCRA, and the question was, can I terminate somebody who doesn't have any leave left and is saying, I don't want to come back to work because I'm afraid I'm going to get it. Not because it's a disability like we talked about before. They don't actually have a condition. They have a fear, maybe because of themselves or somebody who lives at home with them. And it turns out that this law actually applies in those situations, or it certainly can, because among the reasons why it would apply is that when an employee is in quarantine or isolation, when the employee is unable to work because the employer directs them not to do so because of a public health emergency, or when an employee is acting in accordance with an extreme public health emergency order. So, and what it does is it allows somebody to have unpaid, well, you can pay them, but it can be unpaid leave for the duration of the public health emergency, which is huge because we don't know. I mean, it could be years. So, so before you terminate somebody for any COVID-related things, you need to be sure that you have thought about how to apply this. But the reason this came up for me is because, so you know that the FFCRA would cover leave for somebody who has kids in school who are remote. And so for those days when school is not available or out completely, then the FFCRA did cover that time. And so that wasn't the issue. But if you have an employee who says school is operating either full-time or part-time, but I'm not comfortable sending my kid there because of all these issues, you know, employers were saying to me, well, I'm going to terminate because the FFCRA doesn't cover it. They don't have any other leave. It's not FMLA. Why do I have to keep them employed? Well, it turns out the Department of Labor was asked this specific question, and they have said that because there are words, the last reason for leave is that the employee is unable to work because the employee is needed to provide care or assistance to a spouse, domestic partner, parent, or child. We asked specifically, what does that mean? And the answer was care or assistance does include child care related to COVID, and this law is being applied to cover those times when the employee would not be covered by the FFCRA. So even if that leave still existed and they still had some time, you can't fire them if they want to take the time off that wasn't covered. So in other words, for the days when my kid if my kid is remote school, for the days when they're not in school, the FFCRA would apply. But for the days that they're in school, if I say I voluntarily do not want to send my kid to school, so I'm keeping them home, ordinarily, the FFCRA does not apply to that situation, but now this caregiver leave law does. So you cannot terminate somebody under those conditions. I'm going to pass out if I don't stop talking. So somebody else has to say something.
I can ask a question.
Okay.
I have a couple here. One, do you need to reimburse someone for a personal iPhone, etc., if they're using it for Zoom while working remotely?
Not unless you have a contract that says that you will do so. But generally speaking, you have the option to do that, but you're not typically required to do that.
I think that if you are telling an employee, you now have to go out and get one,
Right.
that would be a different situation.
Right.
And then the next one, with the upcoming holidays, we have reminded staff of the executive order to quarantine when returning from travel. What about when employees have out-of-state visitors from non-exempt states to their home? Can we ask them to report that out-of-state contact and require the employee to quarantine if the visitors did not quarantine or get tested?
I think you can.
I think you can. I mean, there's obvious problems with enforcement and
Right.
so forth, but I think it's lawful to require that.
Right.
So as a practical matter, you tell employees you must report if you have somebody come from a non-cleared state and they don't quarantine and they don't test.
Yeah. So I imagine the way it would work is you would say, you know, in light of the upcoming holiday season, these are our expectations that you will follow these guidelines. And if you're going to be having either traveling or having people to your house that don't follow these guidelines, we want to know about it beforehand. And our expectation is going to be that you'll be working from home, quarantining, however you want to set it up, from home for those 14 days so that you're not coming into the workplace and potentially spreading anything around.
I think that's an excellent point about letting people know. So doing that now and setting forth your expectations, I think is key.
Yes.
And then what happens if you have a workplace of 50 people and 45 say, well, I want my relatives to come visit? Do you think there's any way to limit the number of people? Because then you've got potentially 45 people out at exactly the same time.
I don't think you can limit it. I mean, you can take individual action against people that for not complying, but you can't tell them you can't travel or that you can't have visitors. I mean, that's beyond the scope of what an employer can do. You can only react when they do that.
Well, I mean, there are times when you can tell people not to travel. On general vacation, for instance, if you normally this time of year, you could not allow 45 or 50 people to be on vacation at the same
But
time.
we're not talking about taking time off work. We're talking about on the weekend, they're traveling or people are coming up to visit them.
Yeah, true.
I'll play devil's advocate on this one, because from my view, if you don't think that you can actually accommodate having that many people either working remotely or quarantining in a period of time, I think in most situations, if you're a private employer, you can tell people ahead of time, we do not want you putting yourself in a position where you're going to have these exposures, because that's going to impact your work. And if you do that, if you disregard our advice and you do that, and that impacts our ability to staff or have you come in and work, you might be disciplined for that. I think
That you can do. I
Yeah.
agree with that.
Yeah.
But you can't actually prohibit them from having guests come or from traveling.
correct. You're not going to go busting down people's door to
As much
see
fun
who's
as
sitting
that
around the
might be.
Thanksgiving table. Right. Yeah.
Putting a boot on their car so they
Right.
can't drive away.
Right. Yeah.
But I think the most important point to come out of that is exactly what Josh said, and that is that you convey these expectations. And whether or not there is some kind of hierarchy for the first 5 people who tell me, or the first 5 people with seniority, or whatever it is, and everybody else do that.
What happens, so back to social media, somebody comes in and says, look, here's somebody posted on social media and they're having a gathering. Were they one of the people that said something?
Or just a gathering, I mean, never mind being out of state. What if somebody posts a picture of Thanksgiving in, Joe Smith's house, and there are 40, however, what's the cutoff now? I don't even know.
50, I think.
So there's 52 people in the room. That's back to what we talked about before, I think.
Which implicates all the other social media stuff we've talked about in the past, such as you shouldn't be Facebook friends with your employees. Take it with a grain of salt, because they could have posted this from last year. So don't go off the deep end.
Yeah, I think the place to start with that would be to have a meeting with the employee, assuming you got the Facebook photo through legitimate means, not hacking their account.
And not requiring them to give you their account.
Exactly.
Access.
Let's say this came to you from another employee who's friends with this person. I think you start that conversation with the person who had the big Thanksgiving gathering, saying, look, we got this photo. Is there anything you want to tell me about it? When did it happen? Where did these people come from? Were they from these exempt states? Was there quarantining? And from there, make a decision about, okay, they followed all the rules, or no, they didn't. And if they didn't, then, maybe they need to be at home for 14 days.
And that's the easy situation, though, because that's assuming that you can accommodate somebody being at home.
Right.
And if you can't, then I think then you have to decide, am I going to discipline and
Yeah.
have somebody stay out on unpaid leave, right, for the
Yeah.
2 weeks?
So Jesse used language from the CDC guidance. Are you living with anyone sick or quarantined? That way, if their guests don't get tested or are from an exempt state, the guest is required to quarantine. In which case, we've asked the person to stay home for the length of the guest's quarantine or until the guest gets a test.
Well, but a test is not, it's not definitive. Tests are scary. And that's why the 14-day quarantine, in fact, for employers, if you've got an employee out, whether they have a test or they don't is irrelevant, because it's 14 days no matter what, because it can develop during that entire period of time. In some situations, and we can talk more about those specifically, but I guess I'm not entirely sure on what that question was.
So if you have a guest that's coming to stay with you for 2 weeks, they've had a test, that's not going to necessarily protect your employee, because
Right.
the test only tells you if you're positive, doesn't tell you if you're negative. So 2 weeks into it, the guest could start exhibiting symptoms, and then everyone is going to be quarantined.
And then we have another leave of absence school issue or question. An employee taking a leave of absence due to school closure covered under these leave laws, does an employer have to continue covering health benefits, or can the employer request the employee pay for these premiums. So can an employer offer COBRA during a leave of absence and terminate policies?
Well, I think that depends on what leave law the leave is covered under, right? Because the FFCRA required continuation of health benefits. The FMLA would require continuation, but there's nothing in the, well, I'm not going to say that before I check. I was just checking on the caregiver leave law. I don't actually know the answer to that. I think what it says is you can't take away a benefit they have accrued, but you don't necessarily have to continue it while they're out, which would make sense since it's the duration of the
Right.
emergency. But I'd have to check that and be sure.
And
But it's entirely dependent.
yeah, and I believe under the ADA, if it's an ADA leave of absence, you have to maintain whatever they had before they went out on that ADA leave. If they're under just a discretionary, purely discretionary, non-statutory leave of absence, that might be a different scenario. So it very much depends on exactly why they're out and what they fall under.
All right, 5 minutes. Let's do maybe another question. What's that one above, something about HIV?
Can you cover again what to do with an employee that states that they won't come to work due to medical condition, in this case HIV, doctor's note, yet we cannot accommodate his position in another manner? Can we let him go, or do we need to keep him on payroll until a vaccine is available or some other change with the pandemic? So I think it's
So the HIV is making them more susceptible
to COVID.
to worse consequences of getting COVID,
It's a loaded question.
which is the same as
the one.
Brent's discussion about the person with whatever it was that he had.
I think that you need to think through it in several different steps. First, you need to look, do they have FFCRA leave that's available to them? If yes, they get that. Another thing to think through is, do they have FMLA leave that they might qualify for this? It depends on exactly what's going on. So that might be something that entitles them to statutorily protected leave. If they don't have any of that, we might be in the ADA world of reasonable accommodation. And that very much depends. Can you allow them to work from home? Is there any way you can accommodate that to allow them to do the essential functions of their position? Or, do they just want to be excused from work for an indefinite period of time? And that's where it gets tricky, because the law under the ADA and the Human Rights Act is fairly clear that an indefinite leave of absence with no endpoint is not a reasonable accommodation. But before you pull the trigger on that, you need to be very careful to make sure that there's not some more definite period of time they might be asking for, or other ways that you could accommodate them short of just putting them on an indefinite leave.
But of course, that also raises the question about whether they're a person with a disability at all, because it's not the HIV status that's causing the problem. It's the concern about potentially getting something later on. So we are all going to disagree.
Well, I don't know if we disagree. I mean, what I would do with this person is that I would go through the analysis that they just talked about. And if there isn't coverage under FFCRA or FMLA, and you decide this is not a person with a disability that needs an accommodation, and here's the reason that's important, I would put that person on an unpaid administrative leave. I would not fire them, but I would not keep their position open either. And so there's no skin off your nose to have them. They're technically they're employed, but they're told when you're ready to come back, you let us know, and we'll assess what positions are available at that time. So you're not holding the position open and having a negative impact that way. And that's the difference with an ADA accommodation, because arguably for a reasonable accommodation, you're supposed to keep that position so that they would be coming back to it, at least at the first step. But I wouldn't do that in that situation, right? What do you guys think of that?
That sounds like a good solution.
I mean, if for no other reason than the PR of firing somebody with HIV in the middle of a pandemic for no, when there was no reason why you couldn't just keep them and say, when you're ready to come back, you let us know, and then we'll assess what's available. And if nothing's available, then nothing's available.
So can we ask one follow-up on the holiday question? Is the employer expected to pay for the time that the employee is taking the 2 weeks quarantine time because that employee had friends come from out of state to visit for the holidays.
Not, well, if they still have FFCRA, I think that applies and they would pay, but otherwise I say no.
Yeah.
But they could take other vacation leave or they don't have the EPL yet, but
And certainly if they're working remotely, doing compensable work, they need to be paid for that, but
that's their choice. I mean, that's
That's the employer's choice, I think.
no, the employee's choice to have someone visit them.
Oh,
you
right,
know.
right, right.
So we're taking a super
All
short
right.
break,
So don't go away because we're gonna be back in 10 minutes.
technically 9 now, but yes, and then we'll get to all the questions.
Are we muted?
Yeah.
Welcome back, everybody. It's 1:40-ish, and we're gonna have our last hour of pretty much just your questions and our answers. So there's a whole lot of them that are out there pending, both from the earlier sessions today and from just a few minutes ago. So basically, we're gonna have Karen just run down them one after another. So if you have more questions, feel free to send them in and hopefully we'll get to them.
Okay, so this one is for Josh, based on wage and hour. And they wanted to know if the person will be paid mileage.
So the question, I think, is if somebody is engaged in compensable driving time, do they also have to be paid mileage? Generally, no, although it depends where they're driving and that sort of stuff. So under the federal laws, mileage is not required. Under state of Maine wage and hour laws, mileage is not required. You certainly can if you want to, but you don't have to. There are certain states that have different requirements, like I know Massachusetts is one. So if you have employees down there, or if they're working for long periods of time down there, it might be different, but generally the answer is no.
Okay, and then this one is for Brent. What considerations, if our organization is interested in hiring a competitor provider who has a non-compete?
Well, I guess the consideration, it falls somewhere between yellow light and red light in terms of yellow light meaning caution at the very least. You'll want to have an attorney review the non-compete. The biggest concern is whether or not your organization would be taking advantage of any trade secret or confidential information from that employee, that if you hire that person. And I don't think turning a blind eye to it would work. And a trade secret could include things like certain techniques or know-how that is unique and learned by that former employee at the former organization, and that's not generally just general skill set sort of thing, because you could get sued directly under the Unfair Trade Practices Act if you yourself help to misappropriate or take advantage of someone else's trade secret. And so I'd be wary about if there was any, like I say, confidential information that might be a benefit to you. And especially it'd be risky if the reason why this employee is attractive to your organization is that you think he or she's going to bring something to you that he or she was privy to for the former employer. So that's sort of a short answer.
Can I chime in on that one? Another thing to at least think about is the possibility of what they call a tortious interference claim, tortious interference with a contractual relation. So there are some circumstances where if you hire somebody who's subject to a non-compete and you help them violate that, in theory, you might be contractual or tortiously responsible for that. How often does that actually come about in the court system? It's something that I see threatened often, followed through on rarely, and whether or not you would actually be in violation of that common law is another question entirely. But it's something to think through as part of your yellow light analysis. And I think if you're going to hire somebody who's subject to a non-compete, you should probably have a lawyer look through it and talk to you about it before you go ahead and do anything.
And a quick follow-up to that, because I did want to mention that and one other thing. On the tortious interference claim, I believe, at least under Maine law, current Maine law, they would probably have a weak tortious interference claim against your organization. But that doesn't mean they can't bring that claim
Right.
and embroil you in costly litigation. The other practical consideration is even if the other employer doesn't sue your organization, if they sue your employee or get a court order or something, you might not have a very dependable employee because they might not be able to work for you, as it turned out, or they may not be able to do what it is you thought they could do for you. So as I say, it's somewhere between yellow and red.
Okay, and then we have a question from Kathy, and I think John is going to take this one. What if an employee is paid a flat fee for a job? So for example, $100 for delivering a product, so that they are not paid by the hour and not salary either, but they're still an employee, they're not an independent contractor. How do we handle the earned paid leave for this group? Do we have to assign an hourly estimate to their job so that we can calculate the earned leave, or are they exempt from this new law?
Okay, so they're not exempt, and you're in a perilous position as it is, because if you're paying this person a flat fee, you don't know if they're meeting the minimum wage requirement. I mean, if you're traveling from Portland to Caribou for $100, then you probably are not. Most of the time, maybe it's fine, but you need to keep track of those hours so that you can ensure that you're paying the minimum wage. Now, beginning January 1st, you should be tracking hours as well so that you can track the accrual of the earned paid leave, or you can still do the front loading, which will obviate the need for the keeping the track of the hours for that purposes, but you still have the minimum wage issue. So you really ought to be tracking hours either way.
But in calculating the actual amount that they would be paid for their earned leave, so the law says that you base it on the week prior to the request for the leave. And if this person only delivers once every 6 months, then I think you'd have to look back, well, assuming they actually, well, and how are you going to figure out how they earn, what hours they earn anyway, if it's a flat rate and you're not keeping track of how many hours they're delivering? Because the rate at which they earn this
Right.
leave is directly related to the actual hours
Right.
they work.
That's correct.
Yeah.
And why is this person not an independent contractor? That's what I want to know.
That's
Yeah,
Right, because first you need to get the hours, then you need to figure out how much time they actually accrue. And then, assuming they do accrue any time, you're supposed to use the week before the leave, in which case,
for the rate of pay.
for the rate of pay, but this might have been 6 months ago when they delivered the last package. So you'd have to break down the amount paid by the number of hours they took to deliver it, and that would give you your base rate to determine
Yeah.
how much the earned leave would be paid,
But if they're
right?
doing it every week and it's different amounts, then you could be looking at a complicated situation. So
Yeah. I'd be
Okay.
interested to know why that arrangement.
Another question from Amanda. Can we do our payout of the time based on status? So for example, can we pay out for full and part-time and not the per diem?
No. You mean under the
But
earned leave
under
law?
EPL, I think you can
I
if you're
think-
treating employees similarly.
Wait, no, what? Oh, you mean
when they
payout?
leave.
No, okay, right,
employment.
gotcha.
Yeah, I think
On separation.
I think you can do that as long as you have a clear policy that says it and you treat like positions the same. I think you can do that.
I agree.
Okay, what if we have vacation and sick leave policy? If we don't require them to tell us which category, can we simply ask them which leave they want if it falls under this? Is it okay? Or is that a gray area?
I think what you can do is, assuming that the characteristics of your policies match everything that's required under the law, like we discussed earlier, you can say the first 40 hours of leave that you take in a year for whatever reason, we are making the decision that it's being designated as earned paid leave law. I think you can do that. I don't think you need to ask the employee, do you want it categorized in bucket A or bucket B?
But wouldn't you have to reduce their other buckets though by that amount of time? So you either have to know, or you have to, so let's say somebody had 40 hours of sick and 40 of vacation. And then they used 40 hours of EPL. You either have to say, tell me which one you want to pay down.
Okay.
Or you could reduce both and give them
Pro
only
rata.
half, only 20 hours each. And then they can use that however they want after the 40 of EPL.
You could do that. Or I guess you could say the first 40 hours, you have to take it out of bucket B.
Right.
And we're just gonna do that, and that way they know ahead of time.
And that's the trouble that I've been running into in trying to
Right.
formulate these policies, because you're gonna find that employees do not want it coming out of, well, either bucket really, because if you take it out of sick, then that's time that they're trying to use during the leave for the year for other stuff to save vacation. If you take it out of vacation, they're not gonna be happy because that's time they won't be paid out at the end of the year. One way around that, though, is to make EPL payable at the end of the year if they don't use it, because then there's no downside to them, no matter which bucket you take it out.
Now, if,
Right?
That's true.
If-
And if you're reducing the vacation accordingly, so you're still maintaining the overall number, it works out even.
now, if, let's say you get to the end of the year and you give people, you say, okay, you've used 5 hours, so you've got 35 hours of your earned paid leave left. We're gonna pay you for those 35 hours. What if the employee says, no, I don't want you to pay me for that. I want to keep it and I want to roll it over to the next year.
Then they roll it over to next year and they can earn 5 more. and
So
that's it.
you can't require them to accept the payout of it.
But there's no real incentive not to, because if you roll over 35 hours, that means you're only eligible to gain 5 more hours before you hit the cap for the year. So a rational employee would say, give me the money.
Or if they don't want to have to wait to accrue it, they might say, I know I've got a big trip or something that I'm doing
That's true.
right off the bat and I
That's
want to
true.
have 35 hours right available to me.
I think you can do either. I think you just have to have a policy that says, this is what we're gonna do.
As a school, do you need to have MEPL for the teachers?
Yes.
Unless
Unless they're in a current.
Unless you have a
collective
current
bargaining agreement.
CBA. If you're under a current CBA, this law doesn't apply until that CBA is renegotiated and expires. So you're good for now, but it will be implicated going forward under the next one.
Good point.
And that will be fun to negotiate.
Yeah. It will.
We do those.
So a question from Tracy, for a seasonal industry, is it the industry or how long the EER operates? Or are there examples of industries that meet the seasonal requirement?
I think it's both.
Yes. What- You want to answer? I have the
No,
regulations.
if you've got something authoritative, then it's
I
probably
do.
better than.
I always have authoritative. Yeah, actually, that's addressed specifically in the regulations that were issued and also the frequently asked questions and answers by the DOL. And it defines, it says right here, can you explain the exception for seasonal employees? And it says it expressly exempts seasonal employees as defined by the Employment Security Act. So in other words, if they're exempt under unemployment, then they're exempt under earned paid leave. But if they're covered under unemployment, then they're covered under earned paid leave. So I would recommend checking out the regulations and also those questions and answers.
Okay. Upon departure, can we pay out unused EPL to benefit eligible EEs and not pay it out to non-benefit eligible employees?
I think you can, as long as you're treating similarly situated employees the same. I'm not sure that it would be the wisest thing to do, just because it may not look good for your employees to see the difference. But I think as long as you're treating similarly situated employees the same, I think you can do it. Because you're not required to pay it out at all. And so.
Would it depend though on why somebody was non-benefit eligible? I mean, if it's based on, I don't work enough hours, that's one thing. But what if somebody was excluded because of a pre-existing condition? Then you're treating them differently because of a medical condition. Am I overthinking that?
I don't think that usually the reason you don't get a benefit is that you're part-time.
Okay.
Right. It's not related to because you've got a medical condition. There are other troubles with that.
All right, well, if that's the case, then yeah, I agree with that too.
Okay, the year-to-year carryover, is it anniversary year or calendar year?
Anniversary year. It's the employee's anniversary.
Okay, if we currently have a vacation policy can we change the wording to make it EPL? Or do we have to keep the vacation policy and add EPL to it?
Personally have done it two different ways. I have, in some instances, I have created a separate EPL policy and subtracted that amount of time from the vacation policy and kept both. And other times I have integrated it into the vacation policy and it's now vacation / earned paid leave. So it depends on what you want to do and how your existing policy is set up. It may be more amenable to one way or the other. How's that for non-answer?
Okay. We allow employees to carry over 80 hours of unused vacation time to the next year. So if an employee uses 40 hours of EPL, they can roll over their 40 hours vacation time and then accrue another 40 hours of EPL in the next year and accrue another 80 hours of vacation time.
It depends on how you word your vacation policy. So they certainly get to carry over their 40 hours of EPL. Whether or not you allow them to accrue vacation time of 80 hours, 40 hours, or 0 hours in the next year is up to you, depending on how you want to structure that.
Yeah, that's one of the changes that you might make in amending your personnel policy is no longer allowing 80 hours of vacation to be rolled over, knowing you've got 40 hours of EPL that can be rolled over. Maybe you say it's 40 and 40 instead, but you could allow them both.
Okay. Is it a mandate that ERs offer PTO to include vacation and sick? Or is it okay to have vacation 80 plus 40 of sick time? Sick time is not carried over in this person's organization.
I'm not sure I understand what they're asking.
Repeat the
So
question.
it's
Can
a
you
medical,
separate out sick and vacation is the way I read that.
yeah,
The
so it's a
answer's-
medical professional.
If the question is, do you have to have a PTO policy that includes all leave non-designated, the answer is no. You can have whatever you want. You can have PTO or you can have sick and vacation.
Okay,
If the question's something different, you guys read that
I
differently?
can't, which question is it?
The one
The
that's
one
at
at the
the
very
top.
top. Their mandate. I'm not sure if this is what it's asking, but I'll take a stab at it. And if I butcher your question, let us know. But I think what this person is asking is if we have a vacation policy and a sick time policy, can we keep those policies and just incorporate paid leave into those? Or do we have to make a separate policy? And I think that you can do it however you want. You can have a standalone earned paid leave policy, or you can incorporate it into an existing vacation or sick time policy. You just need to make sure that you're hitting all the bare minimum requirements of the new law.
Yes,
If that doesn't answer your question, I apologize and let us know.
I agree with that. I think that it appears that's what it's asking. And as long as each type of leave has the correct characteristics, you may have to expand the reason why. Well, no, I think as long as it has the correct characteristics for the first 40 hours or 20 hours, that would
Right.
work. So it's really a question of how you integrate that into an existing policy. And sometimes, frankly, it's not worth it to even try because it makes your policy so complicated that it's just going to be easier to have a separate EPL instead of trying to create this complicated matrix.
and then
And
if,
I hate to interrupt, but I don't want to just leave and have you wonder. I need to leave. Thank you all so much for attending this year's employment seminar. I hope I see you all next year again. And thank you all. And I'll see
Thank you, Brent.
thanks, Brent.
Aye.
So another question from Elizabeth, if EEs are exempt and extra hours are needed for a project, they do not get paid extra. They might do this work at home, correct?
Well, if they're exempt,
Yeah,
they're not being paid by the hour.
yeah. So if they're truly an exempt employee, they get their salary regardless of whether they work 10 hours in a week or 100 hours in a week. And if they have to put in, even if their average is 40, if they have to put in extra hours to complete that project, that's subsumed within their salary. You can offer additional compensation if you want to as an incentive, but you're not required to.
Okay, in regards to the new earned paid leave law, if you are an employee that works 30 hours per week, they will earn 1 hour for every 40 hours worked. Is the total number of hours they can accumulate 40 hours or only 30 hours?
40.
It's 40 hours.
It's just gonna take them longer.
And at some point, if they're not working enough hours, there may not be enough hours they work in a year to get to 40.
Right.
So then in that case, it will be less. But right now, if you're working 40 hours, it's going to take you about 10 months to get your 40 hours. So if somewhere between 20 and 40 hours, you'll run out of time, you start earning less.
Can an employer deny an employee's request for vacation time if they know the employee will be traveling to a non-exempt state?
I think no, I think you have to give it to them and then require that they quarantine or whatever when they come back.
I think it depends on if this is vacation time or EPL. If it's EPL, that might be a different
Right.
language answer. But for just plain old vacation time, I think you can.
I think if it's regular vacation time, you can tell them, we're not gonna let you take the time for that purpose. I think that's within your
You're just
rights.
mean.
It may not go over all that well, but I don't see anything that prohibits you from doing that.
But come next year, EPL would be different because that
Right.
would have to, well, I guess you could perhaps show as an undue hardship, but that would be a
Right.
different step you have to take.
Okay, with regards to employees that are tested for COVID, are we able to tell employees that they have to get one type of test versus another, so a rapid test versus a swab, before they can return to work?
I don't think so.
Yeah, I'd be reluctant to say,
I wouldn't
get
get
this
into-
kind
Yeah.
of medical
Yeah.
procedure as opposed to
Yeah,
another.
I wouldn't
Yeah.
get into medical issues at all. Because it may be what's available and maybe they can't do one kind or another. I wouldn't touch that.
So an employee is a cleaner in a healthcare clinic, and there are not 50 employees within a 75-mile radius. They have a doctor's note that they should not work due to a household member's health condition while exposure is possible. They do not qualify for FMLA. Can we discharge them from employment?
Well, this is similar to a lot of the ones that we've addressed now. My first question would be though, I take issue with the last sentence because they may qualify for state FMLA. So I don't think you're out from the FMLA analysis at all. However, if the household member, it depends on whether or not the household member has a serious health condition. It sounds like they might if they have something that could be that much aggravated by exposure. But if they don't have a serious health condition, then it wouldn't be covered under FMLA anyway, or that you're not needed to care for them.
Right.
That sounds like a call Anne Marie question.
Well, that comes back to FFCRA and what I read about the caregiver leave
Right.
law. And in fact, that's probably directly applicable to that situation. Don't fire them until you talk to somebody.
Okay, so from Kathy for the EPL law, can we write a company policy that states that upon termination, we will pay EPL to all benefit eligible employees, but that we don't pay it out to non-benefit eligible employees?
Didn't we answer your question?
Yeah.
Yeah,
Did we answer that one?
we said as long as you keep everyone in the same category being treated consistently, yes. You just got to keep in mind that if one of those people who didn't get the payout comes back in a year, then they get it restored.
I was just trying to, confuse you guys by asking the same question again. Okay, another one, clarification for my question regarding health benefits. I was referring to caregiver leave law. This employee is an essential health worker and not covered under FFCRA.
I mean, I don't know if you guys know off the top of your head, I would have to go back and look up the specific provisions of the caregiver health, because all I have is the section that talks about why somebody's eligible. I don't have the rest of it.
Yeah.
Okay, can you ask an employee that needs to be out of work based on either having COVID or having direct contact with someone with COVID for a copy of the COVID positive test as proof?
Well, I certainly wouldn't be asking for a test result from a non-employee. Because it sounds like if your employee was in direct contact with somebody, so that's presumably some third party who's not an employee, I probably wouldn't be asking for that person's medical records. The test result for the employee, I think, is a closer question.
I think I would probably ask for a doctor's note confirming as opposed to the
Yeah.
actual test result, because
think-
I don't know what else is on there and what info you might get.
I think that's the better course.
Okay. If you are paying staff who are sent home due to a snow day, do you need to pay the remote person staff as well?
I say no.
I say no as well.
All right.
Yeah.
We asked the DOL the same thing. They were classified as IDs, and then DOL had us reclassify them as employees.
This
Oh,
was
that's
the package
yes.
carrier.
Interesting.
Okay.
Well,
Right.
I mean, I guess it goes back to what we said, which is you gotta calculate the hours that it took them to do the delivery and come up with a base rate of pay that it's gotta be over minimum wage. And then when they go out, you apply the last time they worked, right?
Yeah.
Whatever that base was. Right?
I agree.
Okay. we
I
have-
think you gotta be careful when you start telling these people to start tracking their time. Don't put any bugs in their head that there might have been a problem in the past.
Going back to the snow day question, it's not that you're not paying the remote worker should be still working, that's all.
Oh, good point.
Yeah.
Good clarification. No more snow days.
Nope.
But there could be internet interruptions.
We have a current PTO policy which states we will pay out the unused accrued balance should they terminate. Employees may also carry over hours. If we create a separate EPL policy, can we handle it differently and not pay out PTO if they have leave and not provide the carryover option?
The carryover option is required for EPL, but you can have a policy that says that EPL is not being paid out.
Correct.
So you might want to merge the two so that you don't end up carrying over twice.
Can
It's only
you,
5 days.
can you clarify if it's mandatory to have cloth masks, or can employees wear a shield if they prefer with the new order?
I would suggest you check the CDC because at one point, and I don't know if they still are, but they were saying that the shields are not effective and you need to have a mask and a shield. So I would go straight to the CDC and see what they say about what works and what doesn't.
And the governor's order recently actually says cloth masks.
Right, that's right, in one section of it.
Do these rules also apply for nonprofit organizations? The exempt EE at a minimum of 701 per week.
What was the last part?
Yeah, so the exemption amount, in terms of the salary basis test is the same, regardless of whether it's a for-profit or nonprofit employer, at least to the best of my knowledge.
What rules is she talking about?
I believe she's talking about the exemption for FLSA.
Oh, okay.
At least that's the way I'm interpreting the question.
Does EPL have to be paid out, or is it a use it or lose it unless you are rehired within that year and reinstated?
It's both, because you can roll over up to 40 hours. And if you do roll over the 40 hours, you do not accrue any more that year. So it's both, you roll it over, but it's also use it or lose it.
Okay. So from Megan, can you say more about non-competes in the context of business to business contracting? To be conservative, I've omitted non-compete, non-solicitation language in vendor contracts, but I'm wondering if you found any creative solutions to allow these provisions to stand, at least in the context of businesses contracting with other businesses.
So this is an area you have to be careful. There's a couple different considerations here. When you're talking employee to employer, it's one thing. When you're talking employer to employer or business to business, it's a different situation. So there's a couple things to keep in mind. Number one, along with the new non-compete law passed last September, they also passed a secondary law, 599B of Title 26, which prohibits restrictive employment agreements. And that makes it per se unlawful for two businesses to contract with one another not to hire or solicit each other's employees. Even having one of those agreements by itself, even if you don't do anything with it, is a violation of the law and is subject to a $5,000 penalty. So there's that to be, it depends on what you're talking about in terms of a non-compete from business to business, but that's one thing you need to be careful about. Another thing that you need to be careful about is whether or not you're getting into any anti-trade laws or antitrust laws, excuse me, depending on the nature of your business to business contract about not competing with one another. That could be an antitrust issue. So I'm not sure if that's what you're asking about, but you do need to be careful about restrictive agreements between two different businesses.
Okay. We currently have vacation, sick, and personal time, and maybe lumping the time together for staff. Will this cover EPL, or do we need to give staff more time?
Chances are it will be enough time, but it depends how much time you're giving them right now. 40 hours per year is what you're required under EPL. So as long as you're giving them that much at the correct or better accrual rate under the same terms and conditions as required by law, then you can do it. So you can, without more detail, I guess I really can't say whether that's true or false, but you need to make sure that there's 40 hours per year accrued correctly with the correct characteristics in terms of notice and so forth.
Okay, thank you. Elizabeth is coming back to, it's a nonprofit with all exempt EEs, so they have to be at the minimum of 701 per week. If so, then we would be impacted to have to increase pay to that amount. Have nonprofits been sharing any concerns?
I haven't heard any concerns about that, and I haven't looked particularly to see if there's any sort of exception for nonprofits. I'm not aware of one offhand. So I don't know what else to say about that other than, number one, I'd be interested to know if all of these employees do in fact pass all the exemption tests. But if they do, minus the salary issue, it's still not an issue so long as they're not working more than 40 hours in a week. So if you have somebody and you pay them $700 a week, and they would otherwise be exempt, but for the fact they don't meet the salary basis test, there's no penalty or negative blowback from that, so long as they're working 40 hours or less in a 1 week period. If they work more than that 40 hours, then you're going to have to potentially start paying them overtime. But if they're working within that time frame, then it's a moot point anyway. So
Okay, thank you.
I don't understand. Are they asking whether or not all of their employees are going to have to be elevated to this 701 per week and sort of insinuating that that's a hardship?
that's the way that I take it in order to maintain exempt status.
Yeah, because my response to that would be, why do they all need to be exempt? Maybe they don't.
Right.
I mean, if they're not working a lot of overtime in the regular course of their job, they don't have to be exempt just because they meet the standards, right? You can
It's your choice as the
unclassify them, and
employer.
then you just have to pay overtime.
It also seems unlikely that all employees would be qualified for being exempt under the other standards for the professional, executive, and so forth. But that's an aside.
Yeah.
Is there a way around allowing EPL to roll over? We revised our policy, so all paid time is in a PTO bucket. It means the other minimum requirements. However, it is a use it or lose it policy. It resets January 1st and employees start accruing again.
I think there is, and it's called pay it out at the end of the year. Otherwise, it has to roll over if there's some left.
I think the only other option would be to just give them on day one of the next year, front load them and give them all 40 hours, because then at that point, even though they haven't technically rolled anything over, it's a moot point because
That's
they've
the
got
same
all
thing,
40
though.
hours there.
So
So
you've just rolled it over.
you've effectively rolled it over, even if you take it off the books. So
And is this effective 1/1/21?
Yes.
No,
yes,
But we don't know what she means by, this is the same person that was just asking about the exempt. Maybe I don't, well, maybe you want to call and, because I'm worried that we're not answering the question that you are asking.
EPL is effective 1/1/21.
Yeah, but we thought she was asking about minimum
Right,
wage,
minimum wage
which is
is,
also 1/1/21.
right,
Correct.
So I guess the answer is yes, no matter what, no matter what it is.
And it shouldn't be that big of a change from December 30th of this year to 1/1/21, because we're only talking about a difference of 15 cents an hour. So the weekly difference is, it's less than $15 if I did it. So, it's not a huge change in the exemption amount when we hit the new year.
Okay, and then somebody has asked if you could repeat the answer about carrying over or paying out EPL. They were having a hard time hearing, and I think this may even relate to the current PTO policy, which states we will pay out unused accrued balance should they terminate. Employees may also carry over hours. If we create a separate EPL policy, can we handle it differently and not pay out PTO if they leave and not provide the carry out option?
one thing that I want to mention about EPL carryover, that if you're talking about a calendar year, that's a problem because EPL is based on your anniversary year. So on 1/1/22, after that, or the December 31st of next year, after a full year has gone by, for existing employees, that's fine. But for new employees, you're going to have a different year. So when it comes to the end of the year, they may not have accrued all of their time for the year, that year, because they're not on a calendar year. Does that make sense? If not, then ask another question. As for the rest of the question, if you want to not have EPL carry over from year to year, then you pay it out at the end of the year, being the anniversary date or the anniversary date eve, so that then there's nothing to carry over.
And then Elizabeth asked or said, yes, I understand that it's not a big amount, but for one person who is paid $35,000 a year, it's an increase of $1,400 a year. This person is the communications coordinator.
The current exemption amount is $36,000 for 2020. And so I just did the quick math for 2021, it increases to $36,450. So it's a $450 increase over the course of the year. So,
But then this person is not exempt right now.
the person who's making $35,000 right now is not exempt because they're underneath, they don't satisfy the salary basis.
So if you have operated under the assumption that that person was exempt,
Call Josh.
call Josh today.
Okay, and then Megan had a clarification. I'm not talking about business agreeing not to compete with each other. I'm talking about business that agree that they will not solicit the employees of other businesses for employment during the pendency of the relationship. I've taken all this language out of our agreements, but have you found any creative ways to allow these kinds of provisions to remain?
So that's a very interesting question. Generally speaking, 26 MRS 599B specifically prohibits that. So two companies cannot engage in agreement that they won't hire or solicit each other's employees. And that is a de facto violation of the law. There is one issue working its way through the court system right now, which is in the context of temp agencies. Because a lot of temp agencies have provisions within their contracts that say, if we place a worker with you and you hire them directly, then you will owe us a finder's fee of X number of dollars, which is a little bit different. The DOL has taken the position informally so far that they are not going to enforce 599B in that situation, but that is an issue that's actually pending in the Superior Court, and I think is going to get some legs, and it'll be interesting to see where that goes. But that's the only carve out that I'm aware of, the potential carve out, I should say, is in the kind of temp agency or placement finder's fee sort of situation.
Okay, thank you. Elizabeth said she's just going to call. And an anonymous person asked, if the employee leaves, do they have to pay out the EPL?
No. If you've got a policy that says you don't pay EPL out, then you don't have to.
Okay.
If you don't have a policy at all, then it's treated the same way vacation's treated.
Okay, at the NDOL webinar yesterday, they said that you could use your anniversary date or calendar year for the accrual.
I
I haven't seen that.
was gonna say, I felt awfully self-conscious this entire webinar because I had also thought that that was an option. I'll have to go back and double check. I thought that to be the case as well, but I don't know for sure, so we'll.
Well, yeah, I
figure
mean,
that out.
and that would be good in some ways. It would just make it a little bit difficult for that first year until you get synchronized, but I hadn't seen anything to that effect.
Okay, and then Anne Marie, one person was talking a little bit about workers' comp and just wants to make sure that you have spoken everything that you kind of wanted to talk about with workers' comp claims while working from home.
Oh goodness, I could talk about this forever. I mean, I guess we didn't get back to that. So there are a whole boatload of issues about working from home. And a lot of this gets back to why we suggested that there is a clear set of parameters in place for what the employee is actually doing at home, what their hours are, and more specifically, what their work setup is like. Because the kinds of claims that we see from people working at home, I wasn't being flippant when I said before somebody goes to get coffee and trips over the dog, because there are actually more of those cases than you might even imagine. And so then the issue becomes, did it arise out of and in the course of employment? Now that's different than in a work setting, because presumably there are no dogs to trip over in a work setting. But you wouldn't ordinarily limit somebody from going to get coffee. So that's the argument. You know, it didn't have anything to do with my being at home. I was taking a break just like I would do in the office. The other place we see these come up a lot is when somebody is coming or going into their house. And a lot of times it happens in the wintertime, and they slip on their stairs, or they slip in the driveway, or getting in and out of their vehicle. And then it's going to depend largely on what kind of employee are they. So are they a traveling employee, or do they still have a set workplace? Are they coming in periodically? Because, and where were they going at the time? So the claims that we see are like, for instance, I was going to get the mail and I slid in the ice and fell and hurt myself. And the reason I was getting the mail is because I knew it was work-related mail that was coming to me. So there's the connection. Or I was going out to get in my car to come to the place of employment to attend a required meeting. So these claims come up all over the place. And I can't give you a definitive answer about whether any one claim is going to be related or not related, because the decisions are all over the place. And it will depend entirely on an assessment of that person's individual situation. Having said that, there are ways for you to limit potential exposure, though, or at least recognize that you have that potential exposure. So defining the workspace is going to be important, so that an employee can't say, well, I had my earbuds on and I was allowed to roam around the house while I talked on the phone, and then I tripped over the dog, but that's okay because you didn't tell me I couldn't do that. So, you know, you have a set office, you're expected to be at your computer at your desk, you're not expected to roam around just like in a regular workplace. You may also want to consider having an ergonomic assessment of that workspace. As most of you probably are well aware, what your workspace at home looks like is often quite different and maybe temporary. Maybe you've got a computer on, you know, a pile of laundry. Maybe you're in your kid's room temporarily because there's no office space. So you want to make sure you have an actual work site that's conducive to working and isn't going to create a carpal tunnel claim, for instance, or a back injury. And then I would define things like mail. I mean, now it seems like you probably don't even need to send anything by the actual mail. Everything could be done over the computer. So going to the mailbox is not going to be necessary. But there are a lot of steps that you can take to try and limit your liability, but it's absolutely a risk, and in a lot of ways a bigger risk than when you have people in the office and have more control over what they're doing.
Okay, thank you. We have just a couple more questions. So for EEs hired before 12/31/2020, accrual of EPL starts with 1/1/21 And the calendar year is also the 1 year time period where the EPL accrual is capped at 40 hours.
Correct.
How is the 1 year time period calculated for new employees that are hired after January 1st, 21? Calendar year as well, or start of employment to 1 year anniversary of employment?
I would say from start of employment to 1 year anniversary of employment. Because that's the 12-year, that's a 12-year period. It's the same as if you were looking at them for a potential raise, for annual raise or something like that. But if DOL is saying something different, then there's going to have to be a mechanism to synchronize them to the current calendar or to the next calendar year. But I think that it is the anniversary year.
Okay, so unless somebody else has any other questions, I've got one final one. To be clear, there is no way around allowing EPL to roll over. We had combined all paid leave into PTO. However, is it use it or lose it? You should start over accruing on January 1st.
You're entitled to 40 hours of EPL per year. And if you don't use your EPL in that year, it rolls over. And if it rolls over, the amount that rolls over is subtracted from the amount that you can earn that following year. So the rollover is something that's stated in law, says that the employees may roll over up to 40 hours. So that's required by law. The way to avoid that is to pay it out at the end of the year, and then there's nothing left to roll over.
And this is anniversary year, not calendar.
I don't think we've,
At least for people, at least for the immediate future, calendar year and anniversary year, calendar year is going to be the year, because for existing employees, it kicks in on January 1st.
Okay. Thank you. That's all the questions that I have.
all right, folks, we really want to thank you for participating and for all your great questions and for allowing us to do this by Zoom this year. I actually think it turned out quite well, being able to have this discussion, and hopefully you learned a lot from hearing it. We certainly will take follow-up questions. It would be probably easiest if you directed them toward a particular person, any of us here at the table, and we'll do what we can to try and help you. And again, we appreciate your attendance and hope you have a good weekend.
Good night.
Thank you.
Bye.
Bye.